Williams, Mr. Steele, Mr. Adams, and Ms. Renard, good morning. All right. Mr. Kendrick and Ms. Hangerty, good morning. Mr. Huey, where are the Matthews?
He was just in there.
You may, sir. All right. Mr. Nichols, Ms. Westmoreland, Mr. Harvey, good morning. All right, Mr. Ryan, Misty Williams, good morning. Mr. Atkins, Ms. Hilton, and Ms. Love, good morning. Good morning, Mr. Brown.
Good morning.
Mr. Matthews Sr., good morning. Is your son Junior with us this morning?
He will be.
Okay, all right. We'll just account for him when he gets in. All right. Sergeant Ingram, all our jurors here?
Yes, sir. All present.
Okay. All right. Before I bring in our jurors, is there anything I need to take out?
Your Honor, the state has the physical evidence that we discussed yesterday pertaining to the 2017 Act 68 from 72. And so the state, having obtained that evidence, intends to finish the direct examination of Officer Fikes, walking through that physical evidence. There's also, Your Honor, two firearms that can't hear you. Your Honor, there's also two firearms that I have spoken with Sergeant Ingram. They have been safely secured that are in cardboard boxes, Your Honor, with the exhibit stickers on the outside. If any defense counsel, these are the items that the photographs defense counsel took. If anyone wants to see them, I'm happy to allow them to. They're here. It's the same items from that stop, and I wanted to make the court aware of that, Your Honor.
All right. Does anybody wish to examine the physical evidence, or have you examined it already?
I'd like to take a look at it now.
Okay, go ahead, Mr. Adams.
Can you bring those over here?
That's not done.
Hey, oh, okay. Is that the evidence? Okay, all right, okay. All right.
Minus the firearms, Your Honor.
All right.
They're in the back.
It's the keys after the lock. That's what I'm taking. They got the statement box. Key statement box.
Yeah, not a good place for him, I agree.
No.
The keys are in the box, Tim? Keys are in the box?
Yeah.
Okay.
So I got this pointed at you, brother. Hell of a time for a freak accident.
What?
All right, thanks, sir. This key. Yes, both of them. All right, thanks, sir.
Okay, so, Mr. Atkins, who do you have? Do you have Officer Fikes outside?
That is correct, Your Honor.
Okay, all right. Any further issues before I go ahead and call in Officer Fikes and our jurors?
Your Honor, one matter I wanted to discuss. Defense counsel, Mr. Adams, was kind enough to share with the state some body cam that possibly defense could introduce related to the 2018 stop. Per the court's guidance, the state's direct of Officer Fikes is not going to address or discuss anything related to that. It's going to specifically be about what we discussed yesterday. The state, I imagine that that the defense counsel with those addressing a stop that we are not getting into, that neither side will inquire of Officer Fikes about something that we're precluded from introducing.
Does Officer Fikes know that?
He knows that I'm not going to be asking him anything related to that stop.
The 18 stop.
Correct, Your Honor. At this time.
All right. You done, Mr. Atkins?
Yes, Your Honor.
Okay, all right. Mr. Adams?
Thank you, Judge, thank you. I think we need to be clear that the issue that we discussed yesterday has to do with evidence, specifically contraband that was found in the back of the Charger, the second vehicle. We did not say that testimony in regards to the 2018 stop itself was improper, was inappropriate. In 2018, and they had Officer Gant here yesterday. Officer Gant is the person who performed the stop in 2018 on Mr. Williams's car, and it was opposition that's fair game, that's fine. He was charged with speeding in that regard, but what the court specifically dealt with was whether or not the guns, the money, and the marijuana that were found in the second car was admissible evidence, was anything we could get into. And then the court indicated that absent a further showing of some nexus connection by the state, that we couldn't get into that. Now,
So what is it you want to get into, Mr. Atkins?
well, I'm just saying that I want to make sure we're not improperly narrowing the scope of our inquiry. Officer Fikes was involved in that second stop. Officer Fikes had some conversation with Officer Gant. I will be candid with the court. What I've shared with the prosecutors is something that arose in the hearing with Gant previously, which is there's a period of time where Officer Fikes goes up to Officer Gant and specifically tells him to mute his body cam.
Yeah, I remember that.
It's like a minute long. He says, "Are you on or are you hot?"
Yeah.
The officer. Anyway, that to us goes to the credibility of Officer Fikes and doesn't have anything to do with the contraband. There's another portion of the video where Officer Fikes says to Officer Gant, where he goes to Officer Gant, and Officer Gant, they're talking about the fact that Mr. Williams is going to be charged with speeding. And Officer Fikes tries to get Officer Gant to up the charges to reckless driving. He says, if you charge him with reckless driving, we can go in the car. And so to us, that goes to the credibility of Officer Fikes, because the evidence is an officer attempting
I
to...
don't have any disagreement as to any of those two.
Right.
So anything else?
No, because I don't think that opens the door to
All right,
anything.
well, I was just about to say that. Now, all of you are very skilled examiners, but, even the best of us tend to inadvertently do things we're not supposed to. But I'm just going to tell you, with that caution, if you get into or open the door as to anything else by your examination, I may change my ruling, okay?
Understand?
All right, so that's just the caveat in the most dangerous game, okay?
No, I understand.
Okay, all right.
And I'm being very candid with the court and
I appreciate
them
that.
in terms of what I intend to get into.
I do.
And that specifically doesn't go to anything regarding the contraband in car number 2.
Okay.
All right?
Your Honor, if I may.
Yes, sir.
Officer Fikes, and in Officer Fikes' testimony, Officer Gant informed Officer Fikes to specifically, his first interaction, like if Officer Fikes is asked a question about 2018, his first interaction was literally walking up to that Charger and seeing the firearms. And so the state's position is that if Officer Fikes Officer Fikes' involvement was overwhelmingly involved with that Dodge Charger. That's why Officer Gant took the warrants out and handled primarily the Porsche. Officer Fikes' initial encounter was approaching the car and seeing these firearms, and that all is kind of part and parcel of Officer Fikes' involvement. So the state is intentionally not trying to get anywhere close to opening or asking Fikes any questions about the 2018 to not run afoul of this court's guidance on that. And the state doesn't feel that if on cross-examination he's asked questions about this stop, that there's any way to discuss that without, on state's redirect, the facts and circumstances of how Fikes is involved, who he interacted with, what he saw. Because if you just take in a vacuum a statement he made, it's relevant. Why is he on scene? What did he do? And his primary role was being quite alarmed when he saw a weapon in that vehicle. And so his whole interaction, everything he does with that stop is wrapped into the Charger. So the state just wanted to be clear with the court that I cannot envision questioning on Officer Fikes about a stop when he can't discuss the majority of his involvement and how he even got to that location, which was specifically to help Gant, because Gant was going to pull over the Porsche, and Officer Fikes' initial role was he needed help because there was 2 cars in tandem. And so Officer Fikes he's going to testify truthfully about what he did. He's going to talk about the Charger. And so the state feels that either the 2018 stop should not be discussed or it all should come in, because there is not, with the way that the facts and evidence are in this case and his involvement, there is not a way, and the rule of completeness, because if they're talking to him about something he did 30, 40 minutes into the stop, the jury is going to have no awareness, and it's fair to complete the story so the jury is not misinformed of how did Fikes even get to this scene, why is he even here, why is he talking to Officer Gant, how did he even get here, and he's talking to Officer Gant after he goes to the Charger. And their analysis or investigative steps, or if the defense was crossing him about what they just referenced, the way he's thinking about things is all under the lens of just witnessing these firearms in a car. And he mentions the driver's foot was fidgety. And so it's all wrapped together in why he's coming to Gant, his whole viewpoint of the stop. And so the state just wanted to be clear with the court to make sure the court's guidance, because the state doesn't feel that there is a universe where the door won't be opened. And the state feels that if Officer Fikes is questioned about the 2018 stop, then the state, to have the jury see a full picture of why Fikes is there, would be able to talk about everything he saw and did with that car, which goes into what we talked about yesterday, Your Honor.
Are you still not going to try and introduce the guns, right?
Your Honor, at this current time, the state was not intending to introduce anything with 2018 per your guidance.
Okay.
If Fikes discussed what he did, the state did have, and before the court's ruling yesterday, it's Exhibit X-ray. We had 5 photographs pertaining to the firearms, that the money and the marijuana that Officer Fikes and Officer Gant handled with that case. So the state would feel that if we're going to talk about it, if the door is opened, we would intend to introduce the photographs of those firearms. That is what Officer Fikes is testifying about and what he saw and witnessed.
Your Honor, the specific two things that I mentioned to the court have nothing to do with the contraband in the second vehicle.
Well, they do have, I mean, address this for me. He's got to be able to tell why it is it completes the picture in terms of why he was involved. He saw the weapons.
Not if he's talking about Jeffery Williams' car and he's trying to get the officer Gant, to upgrade Jeffery Williams' charges so they can search Jeffery Williams.
That's a totally separate issue, and I agree that goes to bias. Separate issue. What the state's trying to tell me, or the state's trying to just have me rule upon, is whether or not they get to complete the picture as to why Fikes is there to begin with.
Well, I mean, that's, first of all, the state has a little backwards. Gant makes a stop. Gant makes a request for additional officers to get to the location. Not just Fikes, a lot of other officers arrive at the location. And they're conducting their investigation. Gant is conducting the investigation in regards to the speeding ticket for Mr. Williams. The problem for them is that when Fikes comes up to talk to Gant, he's talking to him about Mr. Williams. When he asks him to mute his body camera, he's talking to him about Mr. Williams. When he asks him about upgrading charges, we're talking about Mr. Williams. We're not talking about, it doesn't matter why he's there. By analogy, I'm sorry. By analogy, let's say we had an issue about Officer Fikes' general credibility and bias in how he conducts investigation. And there was another case, separate case, has nothing to do with it, where we have evidence that Officer Fikes has asked another officer to shut off their body cam, or has asked an officer to go ahead and upgrade charges on some defendants so that they could get in, they could search that defendant's car. That goes to that officer's credibility. Sure. It has nothing to do with this case. It has nothing to do with the reason that the person's there. It's just that officer's actions, right, that go to his credibility or his bias. And it shows obvious credibility and bias. I'm sure you can make that determination, but that doesn't open the door to allow them to talk about the second car, because we're not talking about it. We're talking about the second car or contraband that's found in the second car that has no connection or nexus to Mr. Williams.
Okay.
Your Honor?
I still agree, Mr. Atkins. I still agree that it's not relevant.
Your Honor, you agree with the state's position?
No, I agree with the defense's position.
Your Honor, may I respond?
Sure.
OCGA 24-8-822, and I'm going to prevents litigants from
24-8 what?
24-8-822, Your Honor, prevents litigants from misleading the jury by presenting portions of prior statements taken out of context, and it is often essential in order to arrive at the true drift, intent, and meaning of what was said on the previous occasion. And the reason that's so salient, Your Honor, is that it's not just Officer Fikes being there, it's Officer Fikes, the information when he approaches Officer Gant is part and parcel of the firearm. So if he's crossed about, yes, Your Honor.
We covered this yesterday. It doesn't have a nexus. Stop trying to get into it. I'm still not convinced. So, he shouldn't testify about why he was there. It's not relevant at this point in time, because what it does is invites and opens the doors to the weapons. So you're not gonna do that at this time.
Yes, Your Honor. And
what they're trying to assert is they're examining just on bias. That's it. On the 18 stop. I don't see any other reason at this point in time. I still have to, I understand what 24-8 does, 822 does, 822 does, but I'm still not convinced.
Understood, Your Honor. After cross-examination, the state will, depending on how the testimony comes out, approach Your Honor before asking any questions related to that, if the state feels that the door has been opened.
Well, I'll be listening.
Yes, Your Honor.
Okay. All right, is Officer Fikes here?
Yes, Your Honor.
All right, let's go ahead and recall him, please. Summon our jurors for us, please, Sergeant Ingram. Did we excuse him temporarily yesterday? Yeah, okay. Probably need to re-swear him. Probably need to re-swear him, so. You got a lash in it or something? Oh. I tell you, that was one benefit of having cataracts. No, I had cataracts. Well, I got my lenses replaced because I'm old. I've seen too much. Ladies and gentlemen of the jury, good morning. Good morning. All right, okay. Sergeant Ingram, can I get you to re-swear in Mr. Officer Fikes, please? Just because we temporarily excused him as a witness. Go ahead, sir.
I do. David Fikes.
Good morning, Officer Fikes.
Morning.
Welcome back. I am, one brief minute, I'm gonna grab some
Sure.
physical evidence. It's gonna be here in just a couple minutes.
Okay.
Your Honor?
Sir.
The state wanted to ask the court's permission to bring in the safely secured firearms into the courtroom.
You may, sir, as long as they've been rendered safe.
Thank you, Your Honor. Your Honor, permission to approach?
You may, sir.
I'm handing the witness what is marked as 58 Lima. Officer Fikes, what is 58 Lima?
It's the SCCY 9mm
And how do you recognize it?
by my handwriting on the outside of the box.
And what is the, can you open up the box? What is inside 58 Lima?
It's a gun with the toe tag on it. It's got Officer Latif's handwriting on it.
And is that the firearm that you recovered from Defendant Williams' vehicle?
Yes, sir.
What is the serial number on that firearm?
Give me 1 second. It is 112660.
Your Honor, at this time, the state moves to hinder State's Exhibit 58 Lima.
Any objection to 58 Lima, Mr. Adams?
No objection, Your
All right, 58 Lima is admitted and may be published as you see fit, sir.
Thank you, Your Honor. And pursuant to the stipulated agreement between defense and the state is going to publish 58 Lima, and after completion of the evidence, photographs. Your Honor.
I'm gonna check.
What's the basis, sir? Just tell me the basis.
It's irrelevant. What the process is irrelevant.
I'll sustain it. Just shorten your comments for the jury, okay?
Yes, Your Honor.
All right.
The state moves to admit 58 Lima in evidence.
I've already admitted it.
Oh, thank you,
Okay.
Your Honor.
All right.
Permission to publish for the jury?
I've already given you that too.
Thank you, Your Honor.
Okay.
What's on first? Publishing 58 Lima for the jury. Officer Fikes, I am handing you what's been marked as 59 Lima. What is 59 Lima?
This is the FN57 firearm
And how do you recognize it?
by my handwriting on the outside of the box.
And is it a fair and accurate depiction of that firearm that you recovered from Defendant Williams' vehicle?
Yes.
And can you read the serial number on that firearm?
386274703.
Your Honor, at this time, the state moves to introduce into evidence 59 Lima.
Any objection to states 59 Lima, Mr. Adams?
Thank you, Judge. There's no objection.
All right, 59 Lima is admitted, may be published as you see fit.
Thank you, Your Honor. I'm backwards. Publishing 59 Lima for the jury. Officer Fikes, was 59 Lima the firearm that was reported stolen?
Yes.
Handing the witness what's been marked as State's Exhibit 60 Lima. Officer Fikes, what is 60 Lima?
These are the bullets that came out of the FN57.
And how many are there?
31.
And are these the bullets that you recovered from Defendant Williams' vehicle?
Yes.
Your Honor, at this time, the State moves to introduce into evidence 60 Lima.
Any objection to 60 Lima, Mr. Adams? All right, 60 Lima is admitted, may be published as you see fit.
Thank you, Your Honor. With the court's permission, the State would like to pass around 60 Lima to the jury.
Sure.
Thank you, Your Honor. Hold this and just pass it around. Thank you, sir. While they're looking at that, Officer Fikes, I'm going to approach you with 61 Lima.
Mr. Atkins, why don't you wait till they're finished with that?
Yes, Your Honor.
60 Lane.
Yes, Your
And
Honor.
we can continue.
Thank you, Sergeant.
Do we have 60 Lima return, Sergeant Ingram?
Yes, sir.
Okay, all right. Go ahead, sir.
Thank you, Your Honor. Handing Officer Fikes 61 Lima. Officer Fikes, what is 61 Lima?
These are the 9mm bullets that came out of the SCCY firearm.
And are those the 9mm bullets that you recovered from Defendant Williams' vehicle?
Yes.
Your Honor, at this time, the state moves to introduce 61 Lima into evidence.
Any objection to 61 Lima, Mr. Adams? Okay. All right, 61 Lima is admitted and may be published as you see fit.
Thank you, Your Honor. The state is going to pass around 61 Lima with the jury.
All right. Let us know when that's complete and you can go ahead and continue.
Yes, Your Honor. Thank you. Your Honor, approaching the witness after 61 has been passed back.
All right, thank you. What are you approaching with now?
My apologies, Your Honor. I saw Sergeant Ingram move. It is still with the jury.
All right.
Approaching with 62 Lima. Officer Fikes, what is 62 Lima?
The Sprite bottle with the purple liquid.
And how do you recognize it?
It's got Officer Latif's handwriting on the front of it, but I can look through the back of the bag and see the Sprite bottle with the liquid in it.
And is that the bottle that you recovered from Defendant Williams' vehicle?
Yes, sir.
Your Honor, at this time, the state moves to introduce 62 Lima into evidence.
Any objection to 62 Lima, Mr. Adams?
Yes, Your Honor, same objection as yesterday, for lack of foundation.
All right, so noted and overruled. 62 Lima will be admitted and may be published as you see fit.
Thank you, Your Honor. And I'm going to pass 62 Lima with the jury. Thank you, sir.
Thank you, sir.
Officer Pikes, I am handing you what's been marked as 63 Lima. What is 63 Lima?
This is the 2 bottles of promethazine.
And how do you recognize those 2 bottles?
By my handwriting on the front and looking through the back, I can see the 2 bottles.
And are those the 2 bottles that you recovered from Defendant Williams' vehicle?
Yes, sir.
Your Honor, the state moves to introduce and tender 63 Lima.
Any further objection to 63 Lima, sir?
Same objection on the last foundation.
All right, I'm gonna overrule the objection, I'll admit state 63 Lima and may be published to juries you see fit.
Thank you, Your Honor. Handing 63 Lima to the jury. Officer Fikes, I am handing you what's been marked as 64 Lima. What is 64 Lima?
These are the 2 medicine bottles. One's got Xanax in it and one's got various pill bottles.
And how do you recognize those bottles?
These are the pills that I took out of Mr. Williams' car.
Your Honor, at this time, the state moves to introduce State's Exhibit 64 Lima.
Any further objection, Mr. Adams?
Same objection, Your Honor.
All right, noted, and the court will admit 64 Lima over objection and may be published as you see fit.
Thank you, Your Honor. Thank you.
Yeah.
I'm going to hand 64 Lima to the jury. Thank you, sir. Thank you, sir. Officer Pikes, I am handing you what's been marked as 65 Lima. What is 65 Lima?
Bag of multicolored powder.
And how do you recognize it?
Because it's got my handwriting on the front, and I can see it through the back of the bag.
Is that the bag of multicolored powder that you recovered from defendant Williams' vehicle?
It is.
Your Honor, the state moves to tender State's Exhibit 65 Lima into evidence.
Any further objection to 65 Lima, Mr. Adams?
Objection is left unmade, Judge.
All right, I'll note your objection, sir. I'll admit over objection, and it may be published as you see fit, Mr. Adams.
Thank you, Your Honor. Thank you. I am handing 65 Lima to the jury. Thank you, sir. Officer Fikes, I'm going to hand you what's been marked as 66 Lima. What is 66 Lima?
This is the appraisal limb, the Xanax bars that came out of the medicine bottle.
And how do you recognize it?
From my handwriting on the front of the bag, and I can see them through the back of the bag.
And are those the items you recovered from defendant Williams' vehicle?
Yes, sir.
Your Honor, the state moves to tender State's Exhibit 66 Lima into evidence.
Any further objection to 66 Lima, Mr. Adams?
Same objection, Your Honor.
All right, it's admitted over objection and may be published as you see fit.
Thank you, Your Honor. Handing 66 Lima to the jury. Officer Fights, I am handing you what's been marked as 67 Lima. What is 67 Lima?
These are the 4 Adderall pills that came out of the medicine bottle.
And how do you recognize them?
It's got Officer Latif writing on the front, and I can see the pills through the back of the bag.
And are these the Adderall pills that you recovered from defendant Williams' vehicle?
Yes, sir.
At this time, Your Honor, the state moves to tender State's Exhibit 67 Lima into evidence.
Mr. Adams, any further objections, sir?
No objection, Your Honor.
All right, they're admitted over objection and may be published as you see fit.
Thank you, Your Honor. Thank you. I am handing 67 Lima to the jury. Thank you. Officer Fights, I am handing you 68 Lima. You can take a look at that. What is 68 Lima?
These are the purple pills that came out of the medicine bottle.
And how do you recognize them?
It's got Officer Latif writing on the front, and I can see the pills through the back of the bag.
And are those the pills that you recovered from defendant Williams' vehicle?
It is.
Your Honor, the state moves to tender State's Exhibit 68 Lima into evidence.
Any further objections, 68 Lima, sir?
That's my foundation, Judge.
All right, they're admitted over objection and may be published as you see fit.
Thank you, Your Honor. Thank you. Handing 68 Lima to the jury. Officer Fikes, I am handing you what's been marked as 69 Lima. You can take a look at that. What is 69 Lima?
The 24 Lords had pills from Jeffery Williams' car.
And how do you recognize them?
It's got Officer Latif's handwriting on the front, and I can see him through the back of the bag.
Your Honor, at this time, stating you 69 Lima into evidence.
Any objection to 69, further objection, I should say 69 Lima.
Objection, Your Honor.
All right. 69 Lima is admitted over objection and may be published as you see fit.
Thank you, Your Honor. Thank you. Handing 69 Lima to the jury. Thank you, sir. Officer Fikes, I'm going to hand you what's been marked as 70 Lima. You can take a look at that, please. What is State's Exhibit 70 Lima?
Multicolored pill from the pill bottle.
And how do you recognize it?
Officer Latif's handwriting on the front. I can see the pill through the back of the bag.
And is that the multicolored pill that you recovered from Defendant Williams' vehicle?
Yes.
Your Honor, the State moves to tender State's Exhibit 70 Lima into evidence.
Any further objections, 70 Lima, Mr. Adams?
Objection, Your Honor.
All right, it's admitted over objection, may be published as you see fit.
Thank you, Your Honor. Handing State's Exhibit 70 Lima to the jury. Fikes, I'm gonna hand you what's been marked as State's Exhibit 71 Lima. If you can take a look at that. What is 71 Lima?
Single blue pill.
And how do you recognize it?
It's Officer Latu's handwriting on the front, and I can see the pill through the back of the bag.
And is that the pill that you recovered from Defendant Williams' vehicle?
Yes.
Your Honor, the state moves to tender State's Exhibit 71 Lima into evidence.
Any further objection, sir?
Same objection, Judge.
All right. 71 Lima will be admitted over objection, maybe published as you see fit.
Thank you, Your Honor. Thank you. Handing 71 Lima to the jury. Thank you, sir. Officer Fikes, I got one last item. I'm going to hand you State's Exhibit 72 Lima. What is 72 Lima?
These are the rubber bands that came off of the large stack of currency.
And how do you recognize them?
From my handwriting on the front, I can see them through the back of the bag.
And are those the rubber bands that were on the money from Defendant Williams' car?
Yes.
Your Honor, the state moves to tender State's Exhibit 72 Lima into evidence.
Any objection, sir?
No objection to the rubber band.
All right. You're admitted, maybe published as you see fit.
Thank you, Your Honor. Going to hand State's Exhibit 72 Lima to the jury. Now, Officer Fikes, I'm going to come grab some of these exhibits up here. Fikes, I'm gonna hand you State's Exhibits 18 Lima and 19 Lima. As well as 17 Lima. We had talked about these yesterday. Ossifieds are Exhibit 17 Lima through 19 Lima. What are those?
These are pictures of the box that the weapons are in.
Is that the same box that we introduced to State's Exhibit 58 and 59?
Yes.
Your Honor, the State moves to tender State's Exhibit 17 and 19 in evidence.
Any objections to states 17 through 19? Mr. Adams?
Sorry, Judge. No, there's no objection. No objection.
Is it 17 through 19 or 17 and 19?
17 through 19 Lima, Your Honor.
All right. With no further objection, states 17 through 19 may be published as you see fit.
Thank you, Your Honor. Officer Fikes, I'm handing you what's been marked as State's Exhibit 20 Lima through 22 Lima. What are those, Officer Fikes?
These are pictures of the bag and the bullets from the FN-57.
And do those photos depict the FN bullets of State's Exhibit 60?
Yes.
Your Honor, the State moves to tender State's Exhibit 20 through 22 in evidence.
Any objection, Mr. Adams?
No objection.
All right, here it is.
Thank you, Your Honor. Officer Fikes, I'm handing you Exhibits 23 Lima through 25 Lima. What are those?
Pictures of the bag and the bullets from the 9mm.
And are those fair and accurate depiction of State's Exhibit 61, the 9mm bullets?
It is.
Your Honor, the State moves to tender State's Exhibit 23 through 25 Lima.
Any objection, Mr. Adams? All right, states 23 through 25 Lima are admitted and may be published.
Thank you, Your Honor. Trade review. I'm handing you, Officer Fikes, what's been marked as State's Exhibit 26 through 28. What are those, Officer Fikes?
They are pictures of the bag and the Sprite bottle that has a purple liquid in it.
Do those accurately reflect the State's Exhibit 62, the Sprite bottle?
Yes.
Your Honor, the State moves to tender State's Exhibit 26 through 28 into evidence.
Any objection, Mr. Adams?
Sir.
All right, states 26 through 28 Lima are admitted, may be published as you see fit.
Thank you, Your Honor. Officer Fikes, I'm going to grab those and hand you 29 Lima through 31 Lima. You can take a look at those. What are those, Officer Fikes?
The bag that has the 2 bottles of promethazine.
And is that accurately reflect what was admitted to State's Exhibit 63?
Yes.
Your Honor, the State moves to tender State's Exhibit 29 through 31 Lima.
Any further objection, Mr. Adams?
That was the previous objection.
All right, there have been over objection and may be published as you see fit.
Thank you, Your Honor. Officer Fikes, I'm handing you what's been marked as 32 Lima through 34 Lima. What are those, Officer Fikes?
The orange and green medicine bottles.
And do those accurately reflect what was admitted as State's Exhibit 64,
Yes.
the green and orange medicine bottles?
Yes.
Your Honor, the State moves to tender State's Exhibit 32 through 34 into evidence.
All right, any further objection, sir?
That was the same objection.
All right, they're admitted over objection and may be published as you see fit.
Thank you, Your Honor. Mr. Fikes, I'm going to hand you what's been marked as 35 Lima through 37 Lima. Take a look at those, please. What are those, Officer Fikes?
It's pictures of the evidence bag with the multicolored powder in it.
And does that accurately depict the multicolored powder bag of State's Exhibit 65.
Yes, it does.
Your Honor, the state tenders 35 through 37 Lima into evidence.
Any further objections, sir? All right, they're admitted over objection.
Thank you, Your Honor.
That's 35 through 37 minutes.
Yes, Your Honor. Mr. Fikes, I'm going to grab those. I have handed you what's been marked as 38 Lima through 40 Lima. What are those, Officer Fikes?
It's the evidence bag that contains the alprazolam or Xanax bars.
And does that accurately depict what was admitted as State's Exhibit 66?
It does.
Your Honor, the state is going to tender 38 through 40 Lima into evidence.
Any further objections, sir? All right, they're admitted over objection, may be published as you see fit.
Thank you, Your Honor. Officer Fikes, I'm going to hand you 41 through 43 Lima. What are 41 through 43 Lima?
It's the evidence bag that's got the 4 Adderall pills in it.
Does that accurately depict the evidence bag, State Exhibit 67, which was the Adderall pills?
Yes.
Your Honor, the state tenders 41 through 43 Lima into evidence.
Any further objections, sir? All right, they're admitted over objection and may be published as you see fit.
Thank you, Your Honor. Officer Fikes, I'm going to hand you 44 through 46 Lima. What do those depict?
It's evidence bag that's got the 2 purple pills in it.
Is that accurately reflect State Exhibit 68, which was the evidence bag with the 2 purple pills?
Yes.
Your Honor, the state tenders State's Exhibits 44 through 46 Lima into evidence.
Any further objections, Mr. Adams?
No, sir. Same objection.
All right, they're admitted over objection and may be published as you see fit.
Thank you, Your Honor.
44 Lima through 46.
Correct, Your Honor. The state is handing Officer Fikes what's been marked as 47 through 49 Lima. If you could take a look at those, please. What do those reflect, Officer Fikes?
It's the evidence bag that's got the 24 Lord Tab pills in it.
And is that accurately depict what's been admitted as State Exhibit 69, which is the bag with the Lortab pills?
Yes.
Your Honor, the state tenders 47 through 49 Lima into evidence.
Mr. Adams, any further objection to states 48 Lima and 49 Lima? All right, they're admitted over objection and may be published as you see fit.
Thank you, Your Honor. Officer Fikes, I'm going to trade with you. I'm handing you what's been marked as State's Exhibit 50 through 52 Lima. You can take a look at those, sir. What is State's Exhibit 50 through 52 Lima?
There are pictures of the evidence bag that's got the multicolored pill in it.
And does that accurately reflect what's been admitted as State's Exhibit 70, which is the multicolored pill bag?
Yes, it does.
Your Honor, the state tenders 50 through 52 Lima into evidence.
Any further objections, sir? All right, they're admitted over objection and may be published as you see fit.
Thank you, Your Honor. Thank you. I'm handing you what's been marked as 53 Lima through 55 Lima. You can take a look at those, please. What do those depict, Officer Fikes?
It's pictures of the evidence bag that's got the single blue pill in it.
And does that accurately depict what's been admitted as State's Exhibit 71, which is the evidence bag with the blue pill in it?
Yes, it does.
Your Honor, the state tenders 53 through 55 Lima into evidence.
Any further objection, Mr. Adams? All right, admitted over objection may be published as you see fit.
Thank you, Your Honor. Officer Fikes, handing you what's been marked as 56 and 57 Lima. What are those, Officer Fikes?
Evidence bag with rubber bands.
Does that accurately depict what's been marked as State's Exhibit, or entered into evidence as State's Exhibit 72?
Yes.
Your Honor, the state tenders 56 through 57 Lima into evidence.
Any further objection, Mr. Adams? All right, states 56 and 57 Lima are both admitted, may be published as you see fit.
Thank you, Your Honor. Officer Fikes, I just have a couple more questions? Your Honor, the state is publishing 12 Lima. Officer Fikes, are these exhibits that we just walked through and introduced, are they or are they not depicted on State Exhibit 12 Lima?
They are.
And publishing 13 Lima? Officer Fikes, do you see any of the items that we just walked through and introduced any evidence depicted on 13 Lima?
Yes.
And what with the cash with the $49,000 that you recovered in the bag with defendant Williams' credit cards, what did you do with that money?
I put it into a evidence locker.
And what happened to the money?
At some point, it was taken to the bank and deposited, but once I put it in the evidence locker, I don't see it again.
Understood. And why did you photograph all of these items, including the money, as depicted in 12 Lima and 13 Lima on scene?
Just for digital evidence to show what was recovered on scene.
And which of these items were recovered from the hidden compartment in defendant Williams' car? And if you need to review these items, let me know.
This right here with the marijuana, and then these two medicine bottles were in the compartment.
Thank you, Officer Fikes. One brief moment, Your Honor. Your Honor, I'm approaching Officer Fikes with State's Exhibit 59 Lima. It's been admitted as 59 Lima. Officer Fikes, is 59 Lima the gun that you recovered from the red and black bag with defendant Williams' credit cards?
Yes.
No further questions for Officer Fikes, Your Honor. Thank you, Officer Fikes.
Any further recross, sir? Go ahead.
Officer Fikes, get your assistance, please. And if I can also beg the court's indulgence and the state's indulgence to, I'd like to use some of their exhibits and ask them if they could put those up on the screen as I request. Officer Fikes, I'd like to, the promethazine, the bottles and the guns and so forth, do you have the fingerprint analysis that shows Ms. Williams' fingerprints on those that I can publish to the jury?
No, sir. No, sir.
No? No fingerprints?
No, sir.
The object of any investigation, when items of contraband are found, to determine who the contraband belongs to, right?
I'm not understanding what you're asking.
You don't understand that question?
No, sir. Can you rephrase it?
Sure. Let me break it down for you. When you have an investigation where contraband is found, and there are multiple people around the contraband, one of the things that you would want to do in your investigation is try to determine, through your investigation, who the contraband belongs to. Is that true?
Objection, Your Honor.
Basis.
Compound question.
I'll sustain this to form. Give him the case, Mr. Adams.
All right. If contraband is found, you do an investigation. True?
True.
And when you do that investigation, you're trying to find things out. True?
True.
Right. When contraband is found and there are multiple people around that contraband, your investigation is trying to find out who it belongs to. True?
True.
Okay. Now, I noticed that in a lot of the questions you answered about the items that were found in the vehicle, you answered, well, this is, for example, an item that was found in Mr. Williams' car. You remember replying to that?
Objection, Your Honor.
Basis.
It's a compound question.
No, it's not. Overruled.
You remember responding in that manner? This is an item that was found in Mr. Williams' car?
Correct.
Okay. Now, you did not answer this was an item that was found in a bag next to Cedric Jones. You never said that in any of your answers, did you?
No, sir.
But in fact, the items that you're referencing, the guns, the money, all of that, were found in bags in the back of the car, right?
Right.
Cedric Jones was the person in the back of the car, right?
Right.
Cedric Jones was, in fact, closer to the items than anybody else in the car. True?
That's not true.
It's not true?
No, the red and black bag was sitting dead center of the car. Any of them had access to it.
They didn't ask you whether any of them had access to it. Cedric Jones is in the back seat of this Maybach, correct?
Correct.
The bag is in the middle of the back seat of the Maybach, right?
On the floorboard.
On the floorboard. And so your testimony to this jury is that Cedric Jones is not the one who was closest to that bag?
Correct.
Okay, that's your testimony.
Yes, sir.
All right. What about the compartment in the back of on the back seat, right? The pull down that you talked about. Who was closest to that?
Cedric.
Okay. Now, the items that you found back there, though, when you were asked about them, you didn't say, oh, the items that were closest and most accessible to Cedric Jones. You didn't answer that one, did you?
I was asked if those were the items that were found in Jeffery Williams' car, and I answered yes.
Right, but in some of your answers, you specifically took it upon yourself to make sure you referenced that these are the items found in Mr. Williams' car. Isn't that true?
Objection, Your Honor.
Basis.
Argumentative and inferring what the witness intended.
Overruled. It's on cross.
That's
Yes.
true? Okay. Now, this is 2017 when this incident occurred, right?
Right.
It's about 6+ years ago. Is that right?
Correct.
September 24th, 2017, right?
Right.
Your testimony is that you're a Brookhaven police officer at that time, right?
Right.
You had been a police officer for some time by then.
Correct.
How long had you been a police officer by the time 2017 had rolled around?
Probably 11 years.
11 years you've been a police officer in South Carolina.
No, hold on. Yeah, probably 11 years.
11 years? South Carolina, right?
Right.
Was that Anderson
Anderson.
and Gwinnett County?
Yes, sir.
Okay. And so here you are in Brookhaven in 2017. It is about, what, 7:09 p.m.?
If you want me to look at my report, I can give you the time, but I don't recall what time it was. It was in the evening.
You were heading to dinner?
Correct.
Okay. But you were on duty?
Right.
Okay. So you're heading to dinner, and this is an area that you patrol, all right?
Right.
This is near the PDK, Peachtree DeKalb Airport, right?
Right.
Private airport, or owned by a municipality, right?
It's a private airport. I don't know who owns it.
It's not Hartsfield.
Correct.
Right? Okay. Private jets and planes land at that airport, right?
Right.
Private jets and planes take off from that airport.
Right.
Any entertainers, sports figures, private individuals use that airport to come and go from. True?
Objection, Your Honor.
Basis.
Speculating of who comes out of that airport.
I sustain the objection.
Do you know? Do you know whether or not this is an airport that's used by celebrities, sports figures, private individuals?
Objection, Your Honor.
Basis,
relevance.
I sustain the objection.
There's more than one entrance to the airport, right?
There's one main entrance to the airport. I don't know if the other ones are all limited access like the one they first turned into.
Okay. The one with limited access is limited access, but it's an entrance to the airport, right?
Right.
And then there's another entrance, right?
Right.
So there's more than one entrance to the airport. True?
True.
Okay. So, September 24th, 2017, you're on, was it Claremont that you're on?
Correct.
All right. Can I have the state, please, put up what I think is marked as their State's Exhibit 1 Lima, I think it's 1 Lima, 1, the map of the DeKalb Peachtree Airport. All right. Judge, do you mind if I step close to the witness and the
No.
screen?
No, no.
You still got that pointer with you over there?
Right here.
Go ahead and grab that. Get over it. All right. Does this map show where you were at the time you first saw the vehicle?
Just barely. I was right here near Bragg and Claremont.
Okay, let's try exhibit number 2, please. All right, how about that one?
Yes, sir. Right here.
All right. Go ahead, point again and then keep the point up there. Is that where you were?
I was traveling in the left lane going northbound.
Okay, that's on Claremont Road, right?
Correct.
All right, do me a favor also, while your back is turned, I want to make sure that Madam Court Reporter can hear you. Keep your voice up a bit, please. And then also folks in the back there can hear you. All right, so you're on Claremont, and show us where you first see the vehicle.
It was somewhere right in this intersection, right about this area.
Okay? Was it heading towards you?
No. I was traveling northbound and they were traveling northbound in the right-hand lane.
Okay, so that you were behind the vehicle.
No.
No?
They're in the right-hand lane. I was in the left-hand lane.
Okay. Were you in front of them or were you behind them?
I was beside them.
You were beside them. Okay. And at some point, do they pull ahead of you or do you pull ahead of them?
They pulled ahead of me.
Okay, and where did they go?
Where did they go?
Yeah.
You're going to have to go to the next slide.
Okay, well, let's stay there for a while. Okay? So it's about a little after 7 on the 24th. It's September. But if I remember your testimony correctly, it was still light out, right?
Right.
Okay. You can still see. I mean, it's still daylight.
Right.
Hadn't gotten dark yet.
No.
Okay. What you indicated was that you noticed that this car next to you, and you can see a reflection in one of the windows of the car. Is that what you said?
In the windows.
The windows of the car.
Right.
One window, right?
Yes.
Okay. And you said that's what drew your attention to the vehicle. Is that right?
Correct.
All right. So we've got we've got States 3 up there. Does that show us where you are and where the vehicle went after you first saw it?
No, it needs to go up one more.
Okay. Let's see. Let's try 5.
That shows it.
Okay, there we go.
Right here.
All right. So the vehicle is traveling north.
North.
Okay, on Claremont, right?
Yes.
And you see them turn into where that blue arrow is, right?
I see them turn into this entrance right here.
Okay. You were behind the vehicle at that time.
Yes.
Okay. And you are still traveling where? In the left lane?
In the left lane.
Okay. And at that point, you have already noticed that according to your testimony anyway, that you can see a reflection in the windows of the car, right?
Correct.
Okay. Now go ahead and have a seat for a second. Let me ask you a couple of questions. Let's leave that up there for right now. I got a couple of questions about that. Now, when you were testifying yesterday, you indicated that you noticed this window tint, but you didn't blue light or pull the car over right away, right?
No.
You actually watched the car for a while, according to your testimony yesterday, right?
Yes.
You indicated that you didn't blue light or pull the car over because you were waiting for an NCIC response. Isn't that right?
Correct.
Now, the truth is, though, that when you first saw the vehicle, right, and it went past you, you ran the tag right away, didn't you?
Correct.
That was the first thing that you did.
This is common practice for me.
Didn't have to, if it was common practice. That's what you did. That's the first thing you did, right?
Yes.
Okay. So by the time the car is going forward and turning into the airport, have you already gotten a hit back that who
Probably
the car
so.
belongs to?
Yes.
Okay. Now, when the car comes out, does it at this point head towards you?
No, it came out and turned left and went south on Claremont Road
Okay. And where are you at that point?
in the turn lane.
Okay. You're just sitting in a turning lane, right?
Right.
Okay. Lights off, lights on.
My headlights or my blue lights?
Your headlights.
They were on autos, so I don't know if they were on or not.
Okay. And so the car travels away from you, right?
Yes.
And do you follow the car at that point?
No.
Okay. What do you do?
I watched it in my mirror for a minute. And I saw they were turning on their brake lights several times, so I pulled off on 9th Street.
Okay. Car wasn't speeding, right?
No, I don't know. I don't have radar in my car.
Car didn't appear to be speeding, right?
No,
The car wasn't committing any traffic violations, right?
not at that time, no.
Okay.
Other than the window tint.
All right. They had just come out of, and you said earlier, you pull over folks for window tint all the time, don't you?
Correct.
It wouldn't have had anything whatsoever to do with the fact that you saw 3 black guys in a Maybach, right?
Objection, Your Honor.
What's the objection?
I sustain the objection.
Your Honor, the state asked the question yesterday as to whether or not he knew the race of the individuals in the vehicle.
Objection, sir. What's your basis?
What's the basis for my objection?
No, I'm gonna sustain the objection. All right? I don't need a speaking response, Mr. Adams. Go on.
Thank you, Judge. Okay. You at some point turned on your blue lights, right?
Yes.
Car pulled over,
Yes.
and it responded right away, right? Car didn't take off or anything like that, just pulled over.
Right.
You get out your car and you go up to the vehicle. You go up on the passenger side, right?
Right.
And maybe I heard you wrong. You testified yesterday that you knocked on the rear quarter panel of the vehicle and the back window rolled down.
The back passenger window rolled down.
Right. But in fact, the front passenger window is the one to roll down first, right?
No.
No?
No. The back passenger window rolled down first.
You didn't put in your report that you wrote that the first window to go down was the front passenger window?
I don't believe so.
You need to refresh your memory?
Sure.
You got your report in front of you?
Sure.
Take a look at it. Read it to yourself. If it helps refresh your memory, when you're done, just go ahead and look up for me.
Yeah, that's correct. The front passenger window rolled down.
All right. And then you were on the passenger side, right?
Right.
So it rolled down, and then the other window was rolled down also, right?
They rolled it down after.
Okay. And so you're able to see inside the car at that point, right?
At which point?
At the point that you're standing on the side of the car.
I couldn't
front
see in the
passenger
car
window
once.
down.
When,
Sorry.
My apologies. Go
I
ahead.
didn't get, no, I didn't get the
Yeah, let me, at the time when you're on the passenger side of the car, sir, and either the front end or the rear passenger windows roll down, are you able to look into the car at that point?
yeah, that's what I was trying to clarify. Once the back window rolled down, I could see in the car.
All right. And let's see, Cedric Jones sitting in the back with some, Kentucky Fried Chicken in the
Right.
bag or box or something, right?
Yes.
All occupants of the car in there eating some food?
I don't think any of them were eating it.
Okay.
I mean,
So,
I don't-
Kentucky Fried Chicken bag?
Yes.
All right. There came a point where you had all 3 individuals to exit out of the vehicle. Is that right?
Right.
Okay. I can have the state to go ahead and put up their 16 Lima. Oh, let's say 16. Is that 16 or is that 15? Tell you what, I'm looking for the picture of Mr. Williams. 16. All right, yeah. All right. That's Mr. Williams, right?
Yes.
Okay, he's an individual who was in the front passenger seat of the car, right?
Right.
Right. He was made to get out of the car and sit right there on the pavement, right?
Yes.
And that's how he looked on that day, true?
Yes.
What's his shirt say?
Fear of God.
Say it again?
Fear of God.
Fear of God. Okay. All right. So he's sitting on the curb. Mr. Jones is sitting on the curb, correct?
Right.
And Mr. Kitchens is also sitting on the curb. Is that right?
Correct.
All right. At some point, you go into the vehicle and you search the car.
Right.
You found in the, Mr. Kitchens, by the way, was driving the car, right?
Right.
And by the way, all of these things that you're observing, keep that picture up, please. I got some more questions I want to ask about it. All of these things that you're observing become part of your investigation, right?
Yes.
And so one of the things that you notice is that in this vehicle, that by this time you know is registered to Mr. Williams.
Right.
Now, is it registered to Mr. Williams or is it registered to Mr. Williams' company?
It said Jeffery Lamar Williams.
Okay. And so by this point, you know that this car is registered to Jeffery Williams, right?
Right.
But you also know that it's not being driven by Jeffery Williams, true?
True.
You know that he's a passenger in a car,
Right.
just like Mr. Jones is a passenger in a car.
Right.
You don't have at this point, any personal knowledge whatsoever about anything that's going on in the car or any of the contents of the car. True?
True.
Okay. You find what you identified as, in the front seat, as some, I think you call it either shake or what you thought to be marijuana residue on the floorboard of the front driver's area, right?
Right.
Okay. You find the Sprite bottle states 62L. You find the Sprite bottle on the floorboard, right?
Right.
Front floorboard.
Front passenger floorboard.
Front passenger floorboard.
Right.
Everything else, well, on Jeffery Williams, you take $2,924 that he had in his pockets.
Again, I had to look at my reports, find the exact number.
Sounds about right.
Roughly. Yes, sir.
Okay. All right. Everything else you find in the back of the car, right?
Right.
Okay. Now, I'm gonna jump forward a bit. All right, so stay with me and then come back. You ultimately ended up taking out warrants. You can take the picture down. Ultimately ended up taking out warrants, right, for Mr. Jones, Mr. Williams, and Mr. Kitchen. Is that right?
Right.
Okay. You charged Mr. Jones, Mr. Williams with possession of the items that you found in the car, correct?
Right.
Including the gun.
Right.
Now, I want to ask you a question about the guns first. Now, the guns were found in a backpack, one of the backpacks in the back seat, right?
There was one gun in each bag.
Okay. All right. So let's talk about the one that you ran and ultimately ended up coming back as a stolen gun. Which one was the one that came back stolen?
The FN.
The FN? That's this one, right?
Yep.
Okay. And by the way, we saw some pictures a little bit earlier, right, of these bullets that were in. Okay, so this is states 60L, labeled as FN bullets, 31 of them, right?
Right.
Where were these bullets? Were they actually in the gun?
They were in the gun.
All of them?
I believe so.
Gun holds 31 bullets?
The magazine.
Okay, all right. So although we have them here separated, I mean, what you actually have is a gun, and the gun had bullets in it, right?
Right.
All right, now. You were actually able, and with the court's permission, if I may approach the witness and put this in front of them. You want to ask
Yes,
this
you
question?
may, sir.
Okay. So, this is the
You're
FS.
showing him what exhibit number you're showing.
Oh, and thank you, Judge. I'm showing him what's been marked as States Exhibit 59L, 59 Lima.
Okay.
All right. So we got 59 Lima. That's the gun that you ran that came back as a stolen weapon, correct?
Right.
It was found in a bag, right?
Right.
On the back seat of the vehicle,
Right.
next to Cedric Jones.
Right.
Okay. It had a serial number on it.
Right.
Serial number wasn't scratched off,
No.
right? There is nothing that, looking at this gun, tells you that it is a stolen gun. True?
True.
You got to run the number.
Right.
You have to run the number to see that it had been a gun stolen at some point out of
East Point.
East Point. Okay. The other gun, containing States Exhibit 58L. Right. This is the 9mm. Of course, permission again to approach the witness.
You may, sir.
This is 9mm, found in the other bag, right,
Right.
next to Cedric Jones, right?
Yeah, right.
Not stolen, just a gun.
Right.
Right. Who's that belong to? Is it registered to anyone?
In Georgia, we don't get guns registered to you.
Okay. Did you get any records that indicate who it was sold to or anything like that?
Yeah, at some point I would have had to know because I got the warrants and it would have said who it was registered to.
So you knew at some point.
At some point, yeah.
Okay. So I want to ask you something about both of these guns, and with the court's permission, one more time. I'm gonna put them both in front.
Actually, that's the one that I would have known at some point because I would have called East Point to figure out the owner.
Okay. What
This
about this one?
I wouldn't have known because it's not stolen.
And by this one, I'm referring to the 9mm.
Right.
All right. All right. So I got both of these in front of you. Now, you are a police officer, right?
Right.
Investigator,
Right.
well-trained investigator, right?
But yeah.
At what point were these guns, because you can obtain evidence from guns, right?
What kind of evidence?
Biological, forensic evidence, something that tells
I
you who
can't
handled
know.
guns.
I can't find that out. No.
You have the ability to have it done, true?
True.
You have the ability to, I'm not trying to trick you. You have the ability to send it off to either the crime lab or somewhere to, for example, have it checked for fingerprints. You can do that.
Yeah, but it's not common practice.
Okay.
For just a stolen gun, for us, is not a common practice unless it's used in a violent crime or something.
You can do that, right?
We could.
Okay. Before we move on to that, any indication that either these guns, bullets, anything tied to any sort of violent crime?
No.
Okay. All right. So let's get back to what you can do as an investigator, right? To kind of tell you who may have handled the gun. You can have it checked for fingerprints, right?
We could.
Did you do that?
No.
Okay. You can have it tested, swabbed, whatever, for the presence of sweat or any other sort of biological information that might tell you who may have handled the gun. That can be done, true?
It can't be.
Did you have that done?
No.
You are not able, as you sit here today, 2024, from back in 2017 to now, you can't tell this jury that you have any knowledge whatsoever, any personal knowledge, any records, anything that tells you who handled those guns.
No, like I said, it's not common practice to get that done unless they're using a violent crime.
I understand that. The bottom line is, if we're trying to tell this jury that there's information about who handled these guns, you don't have any of that information.
No.
So, we know we have two guns in two bags, respectively, in the backseat of a car next to Cedric Jones. We know that.
Right.
Now, there was who's Mona Kalai? Or Kalei?
I have no idea other than her name was on a prescription bottle.
Okay, so there was a prescription. One of the prescription bottles that was found in the car actually had a name on it, right?
Right.
Seeming to indicate that it was prescribed to a person, right?
Right.
A person named Mona Kalai, K-A-L-A-Y-E, right?
Right.
All right. At what point did you reach out to Mona Kalai to find out if that was her prescription or what her prescription was doing in the back of that car? When did you do that?
I didn't.
Okay. So, similar to the guns, right? One of the things, as you conduct an investigation, that you might want to do when you have contraband and multiple people around it, is you might want to investigate to see if you can determine who handled a particular item of contraband, right?
Right.
All right. So we've got two bottles in State's Exhibit 63L, right?
Yep.
These were the items that were found, what were these?
In the middle console compartment of the back seat.
Middle console, right next to or behind Cedric Jones?
That would have been right next to him.
Okay. They're in a plastic bag now. Obviously, they weren't in a plastic bag then. This is an evidence bag, right?
Right.
The bottles were here as they are inside of this bag, right?
They weren't in that bag.
They were out. Free,
Right.
Clear, right?
Yeah.
All right. These were seized, correct?
Yes.
And they're plastic, which means that if you handle them, there's the possibility you may leave fingerprints, sweat, something, biological fluid, something on the bottles, right?
Right.
All right. Now, tell the jury at what point, in an effort to determine who actually handled these bottles, who might have been in possession of them, tell the jury when you sent them off to the crime lab or wherever to have them analyzed for fingerprints.
I didn't.
All right. So, 2017, you found the bottles. We're in 2024. You cannot tell this jury that you have any information about who handled the bottles based on any investigation you did, right?
It's not needed because it's illegal to be in, and if you don't have a prescription for that medication, it's illegal to be in possession of it.
Sure. But if I'm in a car with someone else, and that person is the one who is in possession of and is holding and handling the contraband, you would want to know that it's that person who's been handling and holding it as opposed to me, right?
Not necessarily.
Okay. So let me just ask a question. You didn't bother to have any fingerprint analysis done on any of these?
No.
Not that you couldn't, you just didn't.
It wasn't needed. Again, like I said, it's illegal to be in possession of medicine that's not prescribed to you.
Could you have sent the bottles off to be analyzed to see who handled them?
I could have, but it wasn't necessary
You could have. You did not. True?
because it wasn't necessary.
You're not going to answer that question, are you?
No, I said I could have, but it wasn't necessary.
And the question was, did you?
No.
All right. State 64 Lima. 2 pill bottles. Same question. No analysis done on these fingerprints or biological fluid. anything
No.
like that, right? No?
No.
How long did you say you were? By the time this occurred in 2017, you'd been a police officer for, what, 11 years?
About 11 years.
What was your rank?
An officer.
Officer? Okay. Was that before or after you were awarded Officer of the Year?
After.
So you'd already been awarded Officer of the Year for your investigative skills and policing prior to this date, right?
I got awarded Officer of the Year because I got shot in the line of duty, not for skills.
Okay. Time-wise, right? You were awarded Officer of the Year, and you had all this investigative background by the time this incident occurred in 2017. True?
Right.
All right. All right. State 72L. Rubber bands.
Right.
These were the rubber bands around the money that was found in the bag, right?
Right.
Seized these because they were of evidentiary value, presumably because they were around the money.
Right.
All right. That money ultimately gets deposited or taken into evidence by Brookhaven, right?
Right.
Okay. Okay. You were asked, and you responded to a question about whether you had any training in street gangs.
Right.
Your answer was no.
Right.
I mean, you know what a gang is, right?
I know what a gang is.
Right. You know what a gang isn't, right?
Right.
When you took out the warrants in 2017, you took out warrants for theft by receiving the gun, right?
Right.
You took out warrants for possession of the items, the contraband found in the car, right?
Right.
Actually, you took out warrants of what? Possession with intent to distribute different items?
Right.
Okay. And by the time you actually go to the county magistrate and take out warrants, you have done what you consider to be a thorough investigation. True?
True.
You have garnered as many facts as you think you need to present to this magistrate to get the warrants that are appropriate in this case, right?
Right.
And in September of 2017, you go and you get the warrants that we've just talked about. What you do not get are warrants for any sort of gang offenses, right?
Right.
Because in the course of your investigation, you saw nothing to indicate that any of this stuff found in the car had any connection to any sort of gang offense.
I'm not trained to figure out what's related to gang offenses. I haven't been in any gang training.
You've been an officer for 11 years by this time, right?
Sir, but there's certain gang classes that you take to be able to swear out that warrant because the DeKalb magistrate asks you for facts. And if I can't present those, I've got no way of identifying a street gang.
Yeah, you had no facts, right?
For a gang charge, no.
Right. And so, I mean, you're not the only. Brookhaven has more than one police officer, right?
Right.
It ain't just you.
Right.
There are officers who are above you,
Right.
officers who have greater training than you,
Right.
officers who have gone to the requisite gang classes, right?
I have no idea what they've gone to.
Okay. But you don't know that, but what you do know is that, as you indicated, you saw no facts, no evidence to indicate that there was any sort of gang connection to this case. True?
Objection, Your Honor. Asked and answered.
I sustain the objection. Mr. Adams, before you posit another question.
Yes, sir.
Our jury wants to take a comfort break, and it's about 12:30, so I'm going to just put a pin in it at this point in time.
All right.
All right?
Thank you, sir.
Okay, ladies and gentlemen, the hour is at 12:30, so let's take recess until 1:30. And remember my admonitions I've given you, and at 1:30 we'll come back and we'll see where the day leads us at that point in time, okay? All right, all rise for our jury. All right, please be seated. Our jury has left us. Officer Fikes, enjoy your lunch. Come back at 1:30, okay? Yes, sir. All right, thank you, sir. All right, councils, we'll be in recess until 1:30. I'll see you at that point in time, all right? All right, we're in recess.
Hey there, I'm Jesse Weber, and thanks for watching the Young Thug trial here at Law&Crime, where we bring you live coverage of high-profile trials and individuals accused of committing some pretty terrible crimes. I'll tell you one thing, it's a stark reminder that the world isn't always the safest place. Well, that is why I want to shine a light on this week's trial coverage sponsor, Morgan & Morgan. When you're injured, figuring out what to do next can be pretty overwhelming. That's where Morgan & Morgan, America's largest injury law firm, comes in. A whopping 3 million people turn to them every year. And their process is a game changer. Picture this. You submit your claim, you sign contracts, you upload documents, you communicate with your whole legal team, all from your phone. It's that simple. And what's even more impressive, an attorney reviews your case in just 8 clicks. That speed is remarkable. You submit a claim, they start fighting for you. And if you're concerned about costs, well, you only pay them if you win. There's no upfront fee. So if you're ever injured in an accident or at work, you can check out Morgan & Morgan. You can submit a claim in 8 clicks or less by visiting forthepeople.com/youngthug.
Mike up?
Yes,
All right, can we summon him, please?
Your Honor, before Mr. Fikes comes back to the stand, we address another issue, right? Can't hear you. Before Mr. Fikes comes back to the stand, the state would like to address the outside issue with the court, if that is
Does
permissible.
it have anything to do with Officer Fikes?
No, Your Honor, not, well, yes, ancillarily.
All right, what is it?
We just wanted to inform the court that at this time, we did confer with defense counsel about another witness that has a child care issue for today. We did confer and get an idea of the time that the cross and possible redirect would take. In the alternative, if it looks like we will go past the point that we were initially informed, we would like to know if it's permissible by this court to kind of take that witness out of order before our redirect. Brittany Scott, GDI expert, Brittany Scott.
Counsels, any issues with taking Ms. Scott out of order?
No, sir, I don't think that would be an issue.
Would you like to go ahead and possibly take her now? Is she here?
She is here. I can confirm that. She should be here. And confirm
How long will it take?
She should take about no more than 15, 20 minutes.
All right.
No, sir, I would,
Oh, okay, all right.
I think we can finish Officer Fikes in enough time.
The biggest lie that you lawyers tell me is, I only have 2 questions. That's yours. 2 questions. When you had 4, you really did good because you actually did get it. So. Okay, if you tell me that, here's my concern. I would rather us go ahead and do that, and then we just kind of complete yours and the redirects and everything else, given.
I think we can probably complete cross and redirect in enough time for them to bring that way. As soon as it was told, I think we can. And I feel really versed to kind of interrupting where I am in my cross-examination right now.
Well, I know that's what you'd prefer. Of course, the court controls the method and manner of examination, and for good cause. I'm not doing it because I just want to interrupt your examination. We got a child care witness, and life happens and you practice your vocation. So I would afford that to almost anybody. What time does she have to leave?
He has to leave at 3. So if he can finish his
Okay, all right. Thus you've got about. It's 5 minutes to 2 at this point in time. Mr. Adams, I know you'd rather do that. Let's just go ahead and take her, and then we won't have the issue of breaking or other issues given that.
Sure thing, Your Honor.
Okay,
Yes,
all right. Who is our witness?
This would be GDI expert Brittany Scott.
All right. All right. Let me call the jury, and then you can call Ms. I can explain to the jury what we're going to do. Okay? Summon our jury. Deputy Ham for us, please, sir. All right, thank you, Deputy Ham. Ladies and gentlemen, please be seated. All right, ladies and gentlemen, jury, good afternoon. All right, just as a way of preview, with your permission and concurrence, we have a witness that is to be called today who has child care issues and need to be out of here within the next hour to meet those obligations. So we're going to take this witness out of turn, is what we call it. So I know you're listening to the witness that we have right now, Officer Fikes. Bless you. We're going to go ahead and pause. We'll take those next witness, should be relatively short, and then we'll reconvene with Officer Fikes right after that. Just wanted you to know what we're doing and the reason why. So with that, without further delay, State, call your next witness.
Your Honor, at this time, the state calls Ms. Brittany Scott to the stand.
All right, summon Brittany Scott, please. Ms. Scott, good afternoon, madam. If you would please approach the witness stand. Once you get there, if you'd be so kind to turn and face Deputy Ham to be sworn as a witness before you sit down.
Raise your right hand. Do you swear affirm the testimony you're about to give the court is the truth, the whole truth, nothing but the truth?
Yes.
You may be seated. Can you state your first and last name with the spelling of both, please?
Brittany Scott, Brittany Scott.
Good afternoon, Ms. Scott.
Good afternoon.
Are you employed?
Yes, I am.
Where are you employed?
I'm employed at the Georgia Bureau of Investigations, Division of Forensic Science, also known as the State Crime Lab.
And what is your official designation there?
I am one of the assistant managers of the chemistry section.
And how long have you worked in that capacity?
I have been assistant manager for just about 1 year now. However, I have worked at the crime lab for a little over 10 years.
Okay. And have you worked in any other capacity with another different titles?
Yes, so previously I was a crime lab scientist. I was a drug chemist.
Okay. And what do you do in your current role?
So I just manage all of the different drug chemists in our section.
And what did you do as a forensic chemist?
I tested different items for the presence or absence of controlled substances.
What kind of educational experience do you have?
I got my Bachelor's of Science degree from the Georgia Institute of Technology back in 2013. I then obtained my job at the GBI, where I underwent about a year-long training program to become a scientist.
Okay. And have you ever attended any conferences or trainings related to forensic chemistry?
Yes, I have.
Tell the jury a little bit about those.
Yes, so every year we are required to do continuous trainings, so that can either be internal trainings or external. So a couple of different conferences that I have attended. I've attended the SAFS conference, which is the Southern Association of Forensic Scientists. I've also attended a virtual symposium for the past several years, which just goes over all of the current drug trends.
Okay, and have you ever been admitted to testify as an expert in court?
Yes, I have.
And have you ever testified in Fulton County?
Yes, I have.
Have you ever testified in the particular field of forensic chemistry?
Yes, I have.
Can you tell the jury what forensic chemistry is?
Yes, forensic chemistry is how chemistry relates to the law.
And what kind of information can the results of forensic analysis provide us?
So the forensic analysis in the field that I'm involved in, so chemistry, can give the identification of what different substances are.
And to be sure, have you had an opportunity to perform testing as a forensic chemist yourself?
Yes, I have.
Okay, and about how many times have you performed such analysis?
I've probably worked somewhere between 5,000 and 10,000 cases.
And what type of materials or evidence do you test?
We test all different types of suspected drug evidence. So we test different solid materials, substances, liquids, leafy material, tablets, things of that nature.
How do you test those type of materials that you described?
Yeah, so we have a variety of different tests that we can do depending on what the actual item is and what we suspect the controlled substance or lack thereof might be.
Okay. And do you use certain instruments to test?
Yes.
What type of instruments do you use?
Would you like me to list
Yes.
them all? So some of the different tests that we do, we use the ultraviolet spectrometer or UV. We use gas chromatography, mass spectrometry or GCMS, high performance liquid chromatography or HPLC, and also infrared spectroscopy or IR.
And what are the possible result types that you can receive after the testing is performed?
So different results that we will put out, we will either put out that a substance is negative for any controlled substances, or we will put the positive identification for the controlled substance identified.
Are the tests that you perform at the GBI routinely subject to peer review?
Yes, they are.
And is this the type of testing in this field that generally enjoys acceptance within the scientific community?
Yes.
And do courts typically allow experts to testify about such evidence?
Yes.
And are there standards that control how testing is done at the GBI?
Yes.
And what are those controls, if you will, provide the jury with some information?
So we follow not only our internal GBI policies and procedures, but we also follow an accrediting body's policies and procedures, as well as just some standard practices.
Do you follow those practices each time you test?
Yes.
And is forensics testing something that the average person can do reliably without specialized training?
I don't believe so.
Your Honor, at this time, the state now moves to qualify Ms. Brittany Scott as an expert in the field of forensic chemistry.
Any desire to voir dire witness or any objection?
No, sir.
All right. All right, the court will designate Ms. Scott as an expert in the area of forensic chemistry.
Okay, thank you, Your Honor. Ms. Scott, did you perform any testing for the case that you're here to currently testify about?
Yes, I did.
And what, if anything, do you do after you perform testing?
So after we perform testing, a report is generated listing all of our results and findings. Once that report is complete and reviewed, then the evidence is then sealed back up and returned to the submitting agency.
I have in my hand State's Exhibit 73 Lima, and I am now showing to the defense counsel what has already been shared in discovery. Just a brief indulgence, Your Honor.
Yes, sir.
Your Honor, may I approach the witness?
You may, sir.
Now approaching you, Ms. Scott, with what has already been pre-marked as State's Exhibit 73 Lima. What have I just handed you?
Let me correct this, Lima.
Lima.
Lima's the bean, okay?
That's right, that's right. I'm sorry, Your Honor.
Okay, just want to make sure. All right, okay.
This is the report that I generated for this case.
And how do you know that that is the report that you generated for this case?
So I know this is the report by the DOFS case number at the top. I can also recognize it by my signature on the last page.
And has that report been changed? Has that report been changed, or let me ask you a better question. Is that report substantially the same or the same condition as it was when you initially authored it?
Yes.
Your Honor, at this time, the state now moves to admit State 73 Lima.
Any objections to State 73 Lima, Mr. Adams?
Yes, sir, I would.
What's the basis?
The witness is here. This is the witness's testimony. This written recording would be essentially the same as the witness's testimony. And so the facts that she would testify to would be the same facts.
Okay, so what's your objection?
Well, my objection is that it would be improper bolstering of her.
Okay, I'm going to overrule your objection, sir.
Also, that it would violate the witness rule.
I will rule that too as well.
Also, that it is irrelevant.
I'm going to rule that as well. Anything else?
Second.
Remember, we'll take
Also, that it would be cumulative of her testimony.
overrule, sir.
Your Honor, the state requests permission to publish 73.
It's admitted and may be published as you see fit.
Thank you, Your Honor. Was this report that is now shown on the screen to your left, you can view it next to you, was this report subject to peer review?
Yes, it was.
And I want to speak about what you did in this case as it relates to that report. When did the lab receive evidence for this case?
The lab received the evidence on December 11th, 2017.
And to be sure, what is the DOFS case number associated with this report?
It's the number in the upper right-hand corner, so 2017-10288885.
When was this report authored?
The report date was released on February the 9th, 2018.
And can you tell the jury what type of evidence that the lab received for this case?
Yes, so all of the evidence is listed here under DOFS item 003, and there are several sub-items.
And can you identify those sub-items that are listed on your report?
Yes, so the outer bag, which is 003, the following evidence was placed into a sealed container by DOFS staff, and then all of the sub-items are as follows. 003A is a sealed package containing 1 bottle of liquid. 003B is a sealed package containing the sub-items beneath that. 003B.01 is 1 bottle of liquid, and 003B.02 is another 1 bottle of liquid. 003C is a sealed package containing 2 empty bottles. 003D is a sealed package containing 1 bag of solid material. 003E is a sealed package containing 1 bag of tablets. 003F is a sealed package containing 1 bag containing the following sub-items. 003F.01, orange tablets with the logo of U31, and 003F.02, 1 empty bag. 003G is a sealed package containing 1 bag of partial purple tablets. 003H is a sealed package containing 1 bag of yellow tablets with the logo B3601. 003I is a sealed package containing 1 bag with 1 partial multicolored tablet with a partial MasterCard imprint on it. And 003J is a sealed package containing 1 bag with 1 multicolored tablet with the MasterCard imprint.
Okay. For what reason might there be a letter with a .01 and .02?
So if the package that it was contained in then contained, additional items, then we would separate those out as in 01, 02, and so on and so forth.
And for the items that you've just enumerated for the jury, are you able to tell us that those are the items that you performed testing on in this case?
I performed testing on majority of the items.
Is there any items that you did not test?
Yes.
Which items are those?
003B.02, which is the secondary bottle of liquid, 003C, which were the 2 empty bottles, and 003F.02, which was an empty bag.
Why wouldn't you perform testing on those items?
So I did not perform testing on 003B.02, as it was suspected to be similar to 003B.01, which I did test. And then the other 2 items were both either empty bottles or the empty bag. So there was nothing in there to physically test.
And what were you testing for when you performed testing analysis on the items you did examine?
I was testing for the presence or absence of controlled substances.
And can you tell the jury, I'll start with State Exhibit 62, Lima, which has already been admitted into evidence. And I am now handing you, Ms. Scott, what has already been admitted into evidence as State 62, Lima. Would you tell me what that is? Do you need some gloves to help?
If you would like me to open it, yes.
Thank you.
So yes, I do recognize the bag.
How do you recognize it?
So I recognize it. So that same DOFS case number that was in the upper right-hand corner of the lab report, it is on here as a barcode. And then I also recognize it by the seal at the bottom. It contains my initials and the date that I sealed it.
Okay, and what is that barcode number that you described?
Yeah, so it's 2017-1028885, and then it has the sub-item 003A.
Okay. And given that, is it okay to reference those by the last 4 digits, 3 or 4 digits for simplicity's sake?
As in just the 003A?
Yes, correct.
Sure.
Okay. All right. And at this time, would you open the evidence bag that's in front of you, labeled 62?
Would you like me to cut into all of the inner packaging?
Okay.
Like cut it all the way in? Okay.
Yes, please. You go that up for the jury to see?
Yes.
Okay. Which test did you perform on that object?
So I performed the gas chromatography, mass spectrometry, as well as the high performance liquid chromatography.
And what was the result of that test?
The analysis confirmed the presence of codeine.
And what is the testing that you described? The gas chromatography.
You want me to describe both tests? Yeah. So the gas chromatography mass spectrometry test is a very specific two-part test. So the first part will allow a sample to be broken into its different components if there are multiple components present. The second part of that test detects each of those components, and it will give us a spectrum or a graph that we can compare to either a chemical standard that we run on the instrument at the same time, or we can compare it to reference material. The way that this spectrum or graph is created is very characteristic of the substance, and so it's very similar to kind of puzzle pieces, how puzzle pieces fit together to form one specific picture. All of these fragments that we get from the graph that we're looking at, we can put them together to determine what the substance is. High performance liquid chromatography is a similar two-part test where, again, the first part will separate out the substance into its different components if present. The second part gives us also a graphical representation or a spectrum, although this spectrum is much more simple, but we do compare it to a chemical standard that's run on the instrument at the same time.
And I will be reclaiming, could you replace that and the others back?
Yes.
Thank you. And I am now retrieving State 62 Lima. I am now presenting the witness with State 63 Lima. And if you would be as kind to open, tell me, what is that?
So this goes with the same case. It's sub-item 003B. That contains 003B.01 and 003B.02.
Okay. And how do you know what that is?
Again, it's got the little barcode on it, which it says the full case number and the sub-item 003B. And then it also, at the bottom, I did have to place some evidence tape because the bag was too small to heat seal it back. But again, this is our DOFS evidence tape, and then there are my initials and the date on this side.
What does DOFS stand for?
The Division of Forensic Science.
Okay. Would you be as kind to open and publish the items contained in that evidence bag for the jury, please?
So this bottle is 003B.01. And this bottle is 003B.02.
And did you test both of those items?
I did not.
Okay. And is that referencing the item that you believe to be similar to the same when you were testing initially?
Correct.
And what kind of testing did you do? What kind of analysis did you do on those two items? Or that item that you did test?
I did the same as the item before, so the gas chromatography, mass spectrometry, as well as high performance liquid chromatography.
And for the item, the piece of evidence that you did test, what were the result of your testing?
The analysis confirmed the presence of codeine.
Okay. Would you please replace those into the item? Into the evidence bag, and I'll return them. Now taking from the witness state 63 Lima and handing the witness state 64 Lima. What have I just handed you, Ms. Scott?
This is another item of this case with the sub-item 003C.
Okay. And excuse me. How do you know what it is?
So I know what it is, again, by the barcode on there that says 003C along with that full case number. My heat seal and initials and date are at the bottom.
Okay. And would you please open and publish that particular evidence for the jury that you've done previously? The others?
This is the two empty bottles.
Can you tell the court, tell the jury, excuse me, the condition of the bottle in the tabs?
Yes, so again, these are just empty bottles. There are prescription labels on them, but they are worn, so there's no identifying characteristics on them.
Okay, and was anything done with these particular items in front of you?
No.
Okay. Would you please replace those in the bag? Claim them to you once you've done so. It's faster than I expected. I'm now taking from you state 64 Lima and have now handed you state 65 Lima. What is it that I have just now handed you?
This is sub-item 003D for this case.
And how do you know what it is?
Again, by the full case number and the sub-item 003D, as well as the heat seal, my initials, and the date at the bottom.
Okay, and would you please open that particular piece of evidence for the jury and publish upon having done so?
It is a bag of solid material.
Okay, and is this evidence something that you perform testing on?
Yes.
And what type of testing did you do on this solid material?
So I did the same two tests as before, gas chromatography, mass spectrometry, as well as high performance liquid chromatography. I also used an electronic balance to obtain a weight of the substance.
What was the weight?
Let's see, 7.263 grams.
And did you weigh the other items that you discussed earlier?
No, I did not.
Why not?
So just per our policies and procedures, we weigh or take volumes of certain items and not of others. So the solid material qualified as something to take a weight of, the liquids did not.
Okay, and what did the results of your testing provide you?
The analysis confirmed the presence of methamphetamine.
Okay, and would you please package those that evidence, and then I'll reclaim it from you after I'm done. I am now reclaiming states 65 Lima and have now handed you what has been admitted previously as state 66 Lima. What have I just handed you, Ms. Scott?
This is sub-item 003E.
And how do you know what it is?
By the barcode with the full case number and sub-item 003E, as well as the heat seal, my initials, and the date at the bottom.
And would you please open that package and then contained therein?
So it is a bag of tablets.
All right, and did you perform testing on those tablets?
Yes, I did.
And what type of testing did you perform on those tablets?
The same two tests as previously described, the gas chromatography, mass spectrometry, and high performance liquid
Did
chromatography.
your testing reveal any results?
Yes.
What were the results?
The analysis confirmed the presence of alprazolam in the sample tested.
Is there another name by which alprazolam is known?
It commonly, in pharmaceutical form, is known as Xanax.
And would you please repackage that, and I will reclaim it from you after having done so. Okay, I am now retrieving State 66 Lima, and now handed the witness State 67 Lima. What have I just handed you, Ms. Scott?
This is sub-item 003F.
Okay, and how do you know what it is?
I recognize it by the DOF's case number and the sub-item 003F, as well as the heat seal and my initials and the date at the bottom.
And would you please open and publish what's contained therein for the jury?
So there are more sub-items in this bag. So the 003F.01 are the tablets. 003F.02 is this empty bag.
Okay, and what, if anything, in that particular evidence bag did you test?
I tested the tablets.
And what type of testing did you perform on the tablets?
I performed the gas chromatography mass spectrometry test. I performed a logo identification test, and I used an electronic balance to weigh the sample.
Okay, and what did the analysis reveal?
The analysis revealed the presence of amphetamine.
And what is a logo identification analysis?
So logo identification is where we use a published reference to compare a tablet's color, shape, markings to those of the reference to determine what the tablet is.
Okay, and what were the results of that?
So the results of both tests, or all the tests combined, is the presence of amphetamine.
Was the empty bag tested for anything?
No, it was not.
Is it possible to test that for anything?
It would be possible if there was any sort of residual sample in it, but in this case, it just appeared to be an empty bag, so no.
I am now reclaiming from you. Well, would you repackage State 67 Lima, and then I'll reclaim it and hand you what I have in my hand. I am now reclaiming State 67 Lima, and have now handed the witness. It had previously been admitted as State 68 Lima. What have I just handed you, Ms. Scott?
This is sub-item 003G.
Okay, and how do you know what it is?
The DOFS case number and sub-item 003G, as well as the heat seal, my initials, and the date at the bottom.
And would you please open State 68 Lima and publish for the jury?
So it is a partial tablet.
Okay. And what type of testing did you perform on this particular evidence?
The same type of testing, the gas chromatography, mass spectrometry, the high performance liquid chromatography, and using an electronic balance to weigh the sample.
And what was the weight of that sample?
It was less than 1 gram.
Okay. And can you tell the jury what were the results of your analysis?
Yes, the analysis confirmed the presence of methamphetamine.
And would you please repackage that piece of evidence, and I will then ask you the next. I am reclaiming State 68 Lima, and I've just now handed the witness State 69 Lima, which has already been admitted into evidence. Mrs. Scott, what have I just handed you?
This is sub-item 003H.
And how do you know what it is?
By the DOFS case number, as well as the sub-item 003H, also by the heat seal with my initials and date at the bottom.
And would you please open that evidence package and publish for the jury?
It's a bag of tablets.
Okay. And what color are those tablets?
They are yellow.
And did you perform perform testing on those tablets in that particular evidence bag?
Yes, I did.
And what type of testing analysis did you do on those tablets?
I used an electronic balance to determine the weight. I performed a logo identification, and I did gas chromatography mass spectrometry.
What was the weight of those of that evidence?
10.678 grams.
And can you tell the jury what was the results of your analysis?
Yes, the analysis confirmed the presence of hydrocodone.
And would you please replace that evidence back in that bag? I will put it today. Thank you. I am now reclaiming state 69 Lima, and I've just now handed Mrs. Scott state 70 Lima. Mrs. Scott, what have I just handed you?
This is sub-item 003I.
And how do you know what it is?
By the DOFS case number, sub-item 003I, and the heat seal with my initials and the date at the bottom.
And would you please open that evidence bag to publish what's contained therein for the jury?
It is a bag with a partial tablet.
And can you tell the jury what color, if any, that item has?
It's multicolored, so it's kind of blue and purple and pink.
Okay, and can you tell the jury what kind of testing you performed on that tablet?
I used an electronic balance to determine the weight. I did gas chromatography mass spectrometry, as well as high performance liquid chromatography.
And what were the results of your testing?
The analysis confirmed the presence of methamphetamine.
Okay. And would you please replace that, and I will hand you another piece of evidence. Thank you. I am now reclaiming state 70 Lima, and I've now declared the witness state 71 Lima. And would you please tell the jury what it is that I've just handed you?
It is sub-item 003J.
And, excuse me, how do you know what it is?
Because of the DOFS case number and sub-item 003J, as well as the heat seal, my initials, and the date at the bottom.
And would you please open that evidence bag and publish for the jury?
It is another partial tablet.
And does that tablet have a color?
It's multicolored. It's mostly blue. It's got some pink and green in it.
And what type of testing analysis did you perform on that multicolored tablet?
I used an electronic balance to determine the weight, gas chromatography, mass spectrometry, and high performance liquid chromatography.
Did you weigh that multicolored tablet?
Yes, I did.
And what was the weight, if you recall?
It was less than 1 gram.
Okay. And would you please, and what were the results of the testing for that multicolored tablet?
The analysis confirmed the presence of methamphetamine.
Okay. And would you please replace that piece of evidence, and I'll reclaim it. After doing so. Thank you. Now reclaiming state 71 Lima. Ms. Scott, I would like to ask you, were there any items, what does a 99.73 coverage probability mean?
So that part pertains to any quantitative analysis done. So in this case, it would pertain to the weights. So it's a very statistical term, but in order to simplify it, if say you were to step on a scale 1,000 times, your number fluctuates slightly, but 997 times out of 1,000 times, you're going to get a weight that's within a very close range. So that is what that statement is referring to. It's saying any of the weights that are on the report, there is a small measurement uncertainty window. And so it's basically saying that 997 out of 1,000 times, the weight is going to fall in that measurement uncertainty range. The couple times it would fall outside of that measurement uncertainty range, it would be barely outside.
And I want to direct your attention to page 1 of your report, and you can look at it from on the screen that is to your left. And I want to inquire as to just a little further up. Thank you. Does your report identify from which agency you received this particular, all of these pieces of evidence that we just discussed?
Yes.
From whom?
Brookhaven Police Department.
Is there a person that listed on your report that requested it be tested?
The officer listed on both the submission form and all of the evidence was D. Fights.
And are there subjects related with this particular evidence?
Yes.
What are their names?
The subjects listed on the submission form and the evidence were Cedric Jones and Jeffery Williams.
Does that conclude your involvement with this case?
Yes.
No further questions, Your Honor.
Cross. Mr. Adams, go ahead, sir.
Ms. Scott, good afternoon, ma'am.
Good afternoon.
I feel like you and I have met before. Testified quite often, haven't you?
Probably, yes.
All right. If I heard you correctly, you're the GBI, and you are in the chemistry section.
Yes.
The GBI has several different sections, to use that word, correct?
Correct.
You talked earlier about you being a drug chemist at one point,
Yes.
and you talked about the forensic chemistry portion of the GBI.
Yes.
Now, in addition, I want to talk to you about what you did specifically in this case, but I want to also ask you some questions about the GBI crime lab itself and what it can do.
Okay.
Different agencies, different law enforcement agencies have the ability, and in fact do, send different things to the GBI crime lab for testing. Is that true?
Yes.
For example, you may have a case that involves some sort of sexual issue, and then they may send forensic buccal swabs or for DNA testing, that sort of thing.
Yes.
Right. The GBI crime lab has the ability, for example, to test items for the presence of biological substances on those items. Is that true?
Yes, I believe so.
Okay. And so hypothetically, if I had a bottle, right, and I wanted to test it to see whether or not there was a presence of sweat, saliva, anything like that on it, it can be sent to the GBI crime lab, right?
Again, I can only speak to the drug chemistry part, but yes, there are items that are submitted for other types of testing.
Right. I mean, that is something, maybe not where you work, but that is certainly something the GBI crime lab can and does do, and does. All that. Yes?
Yes, there are other sections in the crime lab that perform other testing.
Okay. Now, do you know when these items came to you, do you know whether or not they had gone to any other portion of the GBI crime lab before they came to you?
I do not believe so.
Okay. Do you know?
From what I can see in the case file, no.
Came just to you, right? As far as you know.
As far as I'm aware, yes.
As far as you know, there's no other testing that was required of any of these or requested of any of these items that came to you, right?
I asked and answered, Your Honor, objection.
Oh.
Of the items that I tested, yes, they solely came to me.
Okay. Now, if I can have the state's indulgence, I think their exhibit was labeled 73 Lima, or Lima. And if I can have you put that up on the screen, please. All right. Ms. Scott, can you see it right there on the screen next to you?
Yes.
All right. This is the front page of your report, correct?
Correct.
And to be fair, your report essentially is just a synopsis of everything that you did and the results of your testing, right?
Yes.
You were asked a little while ago where these items came from, what police department, and you were able to identify that it was the Brookhaven Police Department that sent it to you, right?
Yes, that is who submitted it to the lab.
Came from D. Fikes, that's the person who requested the testing, right?
That was the person listed on the submission form and the evidence.
And the case individuals who are listed here, two people, Cedric Jones, Jeffery Williams, correct?
Yes, that is who is on the submission form and the evidence.
Right. Now, you don't know anything about the persons listed as the case individuals. You just know that that's what the officer put on the submission form, right?
Correct.
Right. You are not able to tell this jury anything about the involvement with any of these items by either Cedric Jones or Jeffery Williams, correct?
That's correct.
The only thing that you know essentially is that there's some items that are sent to you, you're asked to test them, and you're asked to say what they are, right?
Yes.
And while the GBI crime lab and your ability to test can do several things, it cannot tell you, your testing does not tell you who any of these items belong to. True?
Yes, my testing only determines what substances, if any, are present in a sample.
There is nothing about your testing or your finding out that, for example, let's see, 003A, right? That's the bottle of liquid. that tested for, it was positive for the presence of codeine. Right?
Correct.
That's what you know. There's nothing about your testing that tells you who used that, if anyone used it, or who was in possession of it, correct?
Yes, I don't know where the item came from.
Codeine is what? Is that a painkiller?
Yes, so codeine, it does have pain relieving properties.
Codeine is found in, painkiller tablets, Tylenol, stuff like that?
Yes, so codeine is found in multiple different preparations, both tablets and liquid.
It is a legal substance, but it has to be prescribed, true?
Yes.
All right. Same thing with amphetamines and methamphetamines. They are stimulants, right?
Correct.
They are found in a variety of different drugs. ADHD medication.
Yes, there are a couple of pharmaceuticals that contain either amphetamine or methamphetamine.
They are legal substances, but they got to be prescribed, right?
Yes.
Okay. Alprazolam. Am I pronouncing that right?
Yes.
Okay.
Alprazolam, yeah.
One name or one it's Xanax. You find alprazolam in Xanax. Right?
Yes, alprazolam is the primary ingredient in Xanax tablets.
Which is is that an antidepressant? Is that what that is?
Yes.
Okay. Again, a legal substance, but it has to be prescribed.
Correct.
This was submitted to you, if I'm looking at this correctly, on December the 11th of 2017. That's when the laboratory received this item, right?
Yes.
You completed your testing and looks like you issued a report somewhere on or about February the 9th of 2018.
Correct.
Okay. Have you ever worked in any other division of the crime lab other than the chemistry division or the forensic chemistry division?
No, I haven't.
Okay. So it is fair to say, and again, thank you for your testimony, but what you're able to tell this jury is that these items came to you and this is what they tested positive for in terms of what was in the items, right?
Yes.
Okay. And again, nothing in regards to, you can't tell the jury anything other than that, who they belong to, where they came from, anything like that.
Correct.
All right. I believe that's all I have.
Any further examination?
Briefly,
Scott, any redirect?
Yes, very briefly. Mrs. Scott, is codeine a controlled substance?
Yes, it is.
And is it legal to have without a prescription?
It is not.
And in your experience, is codeine typically found in Sprite bottles?
In my
She's an
No,
expert.
I'll stay in the question now. You can rephrase it.
I'm sorry.
You can rephrase it.
I can rephrase it. In your experience, can you tell the jury what does it mean for a substance to be a controlled substance?
Yes, so a controlled substance is just one. There are several different levels that are based on, just how their abuse potential and just how they're used and stuff. So that the highest Schedule 1, are things that could be highly abused, and there's no medicinal use for them, so no prescriptions in the U.S. All the schedules underneath that, Schedules 2, 3, 4, and 5, do have medicinal uses for them.
Okay. And is Tylenol a controlled substance?
Tylenol just by itself is not a controlled substance.
And I want to ask you just a couple more follow-up questions. know all of the other protocols and procedures for the other departments at the GDI?
I do not.
Why wouldn't you?
Because I don't work in those sections, so I know the policies and procedures that the chemistry section uses.
Brief indulgence, Your Honor.
Yes, sir.
And just briefly, in your experience, in your training experience, I should say, is it legal to have codeine in and of itself in a Sprite bottle?
I can't speak to the legality of different substances. I do know that codeine is something that is prescribed, but as far as the legality of what we get, I can't speak to that.
And in your experience, is it normal for it to be found in Sprite bottles?
Objection calls for speculation.
I'm gonna rule that one.
Is it foundation?
Overruled.
In your experience, is it normal for prescription codeine to be found in Sprite bottles?
I have received that in several cases before. However, there is no prescribing information on those bottles.
No further questions, Your Honor.
Anything further, Mr. Adams?
Yes, sir. Who put the codeine in this bottle?
I don't know.
How did it get in the bottle?
I don't know.
You were asked about whether you are familiar with the policies and procedures for the other divisions of GBI Crime Lab. You said you don't know, right?
Correct.
But law enforcement officers know where to send something if they want it analyzed, right?
Objection, Your Honor. Speculation.
I sustain the objection.
That's all.
Anything further from the state?
Nothing further, Your Honor.
All right. May Ms. Scott be permanently or temporarily excused as a witness?
Temporarily excused.
All right, Ms. Scott, I'm going to temporarily excuse you as a witness. That means you'll be subject to further examination. So just leave your contact information with the state, and we'll give you enough time to summon you appropriately, okay? But don't discuss your testimony with anybody except the attorneys in this case, okay?
Okay.
All right, thank you, madam. Okay, is it a state's pleasure to recall Officer Fikes?
Yes, Your Honor.
All right. Can we recall Officer Fikes, please?
And Your Honor, when he left, he was on cross-examination.
We remember. Mr. Adams, come on back up. All right, sir. Whenever you're ready, Mr. Adams.
Thank you, Judge. Officer Fikes, welcome back. Question. When we left off, we were talking, as I recall, about your the charges that you took out in this case. And I am correct, am I not, that you charged Mr. Williams and Mr. Jones with possession of the substances that were found in that car, right?
Correct.
In fact, you went to a DeKalb County magistrate and you swore out warrants, and by swearing out warrants, you requested that warrants be issued for possession of controlled substances, possession with intent to distribute, right?
Right.
Okay. And theft by receiving, is that right?
Right.
Okay. I asked you, and I think your response was that you did not find any information that you thought warranted there being any gang charges in the case. Is that right?
That's correct.
Okay. You did not find any information that suggested to you, as the investigator, that these items found in this car was part and parcel of any sort of racketeering conspiracy?
No, sir.
And just to be clear, I mean, you can take out warrants for whatever you think the evidence leads to, right?
Whatever I can prove to the judge at the time I'm getting the warrants issued.
There you go. And you have not, since 2017, we're 6+ years past that, you've not done any additional, you've not taken out any additional charges in regards to this incident, true?
No.
Now, before you came in here to testify, am I correct that you would have sat down with the DA's office and told them everything you know about this case?
Prior to me testifying, yes.
Yes. You would have told them about everything that you found, right?
Right.
And you would have told them about all the circumstances that led to your making the arrest of Mr. Jones, Mr. Williams, and Mr. Kitchens, right?
Right.
Okay. Did you tell them, when you met with them, that, hey, you all are free to do whatever you want to, but I didn't take out any gang charges? Did you tell them that? Or did they already know?
No. I didn't take out any gang charges, and they already knew that.
Okay. One moment, if I may, Judge.
Yes.
All right. You know, I may have been mistaken, so I'm going to have you maybe educate me on this or remind me of this. When Mr. Williams was asked to get out of the car by you, you certainly had the opportunity to observe what he was wearing, right?
Yes.
Colors, what he was wearing.
Right.
Right. We may need to put that picture up, but of your own memory, you recall him having like a blue, was his shirt blue or what?
I don't remember. I think it was dark blue or black.
Okay, let's see.
I'd have to look at the picture.
Okay, let's do that. Let's look at 16L again, please. Is that dark blue or black shirt, light blue? Writing, the fear of God is in light blue?
Looks white to me.
That looks white to you?
Looks white to me.
Okay. Color's the shirt?
Either dark blue or black.
All right. Let's see 15L, please. Mr. Kitchens. All right, that's Mr. Kitchens you took out and told to sit on the curb, right?
Right.
Wearing a black hoodie,
Correct.
camouflage pants, it looks like?
Yes.
Okay. 14L, please. Mr. Jones. Blue hoodie, blue or black hoodie, right?
Black hoodie. Yep.
Blue shirt underneath,
Correct.
red bandana.
Yes, sir.
What color pants he wearing? I know you can't tell from this
I have
picture.
no-
You remember?
I don't know.
Okay. All right. Let's go back to 16L. Did I hear you say that at some point, after you decided you were going to arrest Mr. Williams, that his jewelry was released
That's correct.
to his, who was the person, I don't know your name, who was the person you released him to? Is it his manager?
I think a cameraman or something. I don't know.
Did you understand that person to be his manager?
No, I think, like I said, I think he said it was a camera guy.
The camera person. Okay. All right. Second judge.
Yes, sir.
Hold on, Mr.
Yes, sir.
Atkins. Any other examination? Okay. Any redirect?
Yes, Your Honor. Thank you. Officer Fikes, beyond the traffic stop, did you continue investigating or have any other involvement with this case?
No, I did not.
And when you make an arrest, do you turn your case over to the district attorney's office?
I do.
Why do you do that?
Because they have a chance to review the case and add charges or, to re-indict charges.
And do you control what charges are presented to a grand jury or brought by a district attorney's office for a case that you work?
No.
Now, Officer Fikes, on cross, defense counsel had asked you about the firearm in the red bag. Do you recall that?
Say that one more time.
On cross-examination, defense counsel had asked you questions about the firearm found in the red bag. Can you
Right.
remember that?
Yes.
I wanted to talk about that. Now, I'm handing you what's been marked as 59 Lima.
Correct.
Was 59 Lima found in that red bag in Defendant Williams' car?
Yes.
Officer Fikes, I'm handing you what's been marked as 72 Lima. Was 72 Lima, what were those around when you got those?
It was around a large stack of currency.
And is that currency found in that red bag?
Yes, it was.
Officer Fikes, I'm handing you what's been marked as 64 Lima. What is 64 Lima, just to remind?
It's a green and orange medicine tube bottle.
And were those items found in the red bag in Defendant Williams' car?
The orange one was. The green one was not.
And Officer Fikes, I'm handing you what's been marked as 65 Lima. What is 65 Lima?
Is the multicolored powder that was found in the orange bottle.
And was that also in the red bag?
Yes, it was.
Did you find a wallet in that red bag?
Yes, I did. I found a wallet with several credit cards with Jeffery Williams' name on it.
Did you find any other identification documents in that red bag other than the ones in that wallet?
No.
And when Jeffery Williams got out of that vehicle, what was in his pocket?
A large stack of money in one pocket and keys to the Mercedes Maybach in the other pocket.
And when you ran the license plate to that vehicle where the red bag was in, whose name came back?
Jeffrey Lamar Williams.
And was the firearm, which is 59 Lima right before you, is that the firearm that was reported stolen at East Point?
Yes, it was.
Officer Fikes, in your experience as a law enforcement officer, do you typically submit every item that you recover to the Georgia Bureau of Investigation?
No,
Why?
because some items don't need to be processed. For instance, narcotics all usually get sent to the GBI because even though with my experience I know what ecstasy looks like, I have to have it tested by the GBI to get those results back. But an object like a gun, like I said earlier, unless it's used in a violent crime, we don't send it off to the GBI.
Officer Fikes, on cross-examination, there was some discussion about when you initiated your blue lights. Do you remember that?
Yes, sir.
Why did you not initiate the traffic stop when you first noticed the window tint?
Because, like I said, I like to run the license plate to see who it comes back to and make sure it hadn't been used in a violent crime or stolen. And by the time I got the return back, there shortly later, they turned into that gated entrance. So I wanted to see where they were going because I didn't think that they knew where they were at.
And Officer Fikes, on cross-examination, there was questions about when you approached the vehicle after you initiated the stop. Do you recall that?
Yes, sir.
Until the windows, when you approached that car, until the mirror tint windows were rolled down, did you have any idea of who was inside of that vehicle?
That's the same question. That was Mr. Matthews.
Officer Fikes, do you recall approaching the Maybach vehicle?
Yes.
When you approached the vehicle, could you see inside it when you first approached?
When the windows were up, I could not see inside of it.
When was the first time when you were in this traffic stop that you were able to physically see who was inside the car with the mirror window tint?
Once the back passenger window was rolled down.
Was this before or after you initiated the traffic stop?
After.
Officer Fikes, do you know what slat means?
No, I've never heard that word.
Publishing 14 million, Your Honor. And Officer Fikes, you had in your training, when you are on the streets, patrolling, doing drug interdiction, what kind of things do you look for in terms of vehicles that are operating on the street?
I mean, there's several different things. Window tint, we look for any violation that we can stop a car for, but things that are out of the ordinary, like extremely dark window tint, or if a car makes a lane change that had no reason to make it. I mean, it just odd behavior, odd driving manifestations.
And once you come within eyesight, so to speak, of a vehicle when you're out on the street, how that vehicle operates or drives after they may have seen you affect your investigation?
It heightens my senses just based on what they're doing, because your average driver that's just out driving is going to see you and they're going to either slow down or they're going to pull over once you hit blue lights. But the fact that they turned in the gated entrance and made that 3-point turn and went back the opposite direction where they were coming from kind of led me to believe they were trying to avoid me.
I'm going to object as speculative and after that be stricken.
I'll stand questions for him.
Your Honor, Officer Fikes, what type of movements on the roadway, or what can a car do that to you, in your training experience, is suspicious or a red flag when you encounter it? What are some examples?
Like I said, a lane change that isn't justified. I mean, you don't just change lanes just to change lanes. You're either changing lanes to make a turn or to go around to, pass a car. a car just pulling a U-turn and going back to where they came from, cars driving extremely below speed limit, extremely tinted windows. There's a whole bunch of it. I mean, that's just to name a few.
One brief moment, Your Honor.
And the other one for
Public
regular
access.
right?
You're right.
All right. When you ran the tag, it gave you a name, right?
Right.
Does it also give you the person's date of birth?
It does.
Give you their race?
Yes.
So the computer check told you that you were behind a car that was registered to a black male by the name of Jeffery Williams, right?
Right.
Thank you, that's all.
Anything further from the state?
Your Honor, no further questions for Officer Fikes.
All right, may Officer Fikes be permanently or temporarily excuse the witness?
Temporarily, Your Honor.
All right. Officer Fikes, I'm going to temporarily excuse your witness. That means you're subject to being recalled at some point in time. We have contact information for you, so we'll give you enough lead time and have you come back with us. The only admonition I give you is just don't discuss your testimony with anybody except the attorneys in this case, okay?
Yes, sir.
All right. Thank you, sir. All right, ladies and gentlemen, much like when we're at the ball game, the seventh inning stretch, so we're going to go ahead and do that. So let's take 15 minutes to do that, and you can take a comfort break, okay? All right, so, and then I'll find out where the afternoon is going to lead us from there. All right, all rise.
Hey there, I'm Jesse Weber, and thanks for watching the Young Thug trial here at Law&Crime, where we bring you live coverage of high-profile trials and individuals accused of committing some pretty terrible crimes. I'll tell you one thing, it's a stark reminder that the world isn't always the safest place. Well, that is why I want to shine a light on this week's trial coverage sponsor, Morgan & Morgan. When you're injured, figuring out what to do next can be pretty overwhelming. That's where Morgan & Morgan, America's largest injury law firm, comes in. A whopping 3 million people turn to them every year. And their process is a game changer. Picture this. You submit your claim, you sign contracts, you upload documents, you communicate with your whole legal team, all from your phone. It's that simple. And what's even more impressive, an attorney reviews your case in just 8 clicks. That speed is remarkable. You submit a claim, they start fighting for you. And if you're concerned about costs, well, you only pay them if you win. There's no upfront fee. So if you're ever injured in an accident or at work, you can check out Morgan & Morgan. You can submit a claim in 8 clicks or less by visiting forthepeople.com/youngthug.
Kearns, I believe it did go to Mr. Kearns.
Mr. Kearns ain't wearing a robe, okay?
I know, you know,
he's a nice fella, but
he
you know,
is.
we talk sometimes. I mean, you know, but you know, if you all could include me on important things like that, I'd greatly appreciate that.
We sure will, and I will forward it
all
to you
right.
right now.
Okay.
We hope it will not take.
Hope's not a strategy.
You are right.
You know, I always say I'm a firm believer in that. So
We would think that the motions would take about 30 to 45 minutes, if that. And so we would like to start Investigator Belknap today. He has been here multiple times, so we would like to start him today if we can, and at least finish him tomorrow.
okay, we need to cover the instruction. We also need to cover what else with.
I think Mr. Steele had a few motions, so I'll let Mr. Steele
All right,
respond to
Mr.
that.
Steele, what else do we have in terms of that I need to cover? Oh, I wasn't talking to you. I was talking to Mr. Steele.
I understand.
Are you his puppet?
Sometimes.
Oh, okay. I wasn't talking to you right now. I mean, I'll give you an opportunity to chat, okay? But can I go ahead and take that first?
Okay. I was nominated by the defense to respond to. Okay, well.
All right. Okay. Whatever y'all want to do is fine. Okay. All right. Mr. Sharp.
Thank you, Your Honor.
All right. What is it?
So, on behalf of the defense counsel, I think that we may, when we're talking about this jury instruction, we may be putting the cart before the horse, so to say. I understand the jury instruction, but we've had numerous discussions throughout the trial of this case about the repeated testimony of Officer Belknap
I get it.
as an expert. And
This is his first time testifying as an expert,
that
right?
is not correct, Your Honor, respectfully. He was the first officer to testify. The state led their case with Officer Belknap's expert testimony. He testified as an expert. He testified about gang histories, about gang identifiers, about gang attire, the history of gangs,
You are
Pete
correct.
Rolette.
You are correct, sir. You are correct.
And they've exhausted his testimony as an expert. We have been under the understanding, based on discussions and based on emails and correspondence with the state and discussions with Your Honor, that Officer Belknap was testified as an expert one time, and going forward from that testimony on the first day of trial, he could be recalled, but to testify as a fact witness on particular overact or charged acts. And we've been under that understanding. We've been operating under that understanding. The state has memorialized their understanding of that. And so now we are in a position where we understand that the state has 4 or 5 different experts regarding gang activity and gang evidence, and now they're trying to call the same expert multiple times in this case as an expert. They've already done that. We've crossed that bridge, and now he is here. Our understanding is to testify as a fact witness. Since he's here to testify as a fact witness only, this jury instruction, I'm not, other co-counsel may feel different than I do, but from my perspective, the instruction is not necessary at this time, because he's just going to be testifying as a fact witness.
Well, it's a limiting instruction, not a jury instruction.
Yeah, a limiting instruction. Yes, Your Honor. And Ms. Westmoreland has something to add as well regarding the correspondence and the rules that we've been operating under with this case so far.
Good afternoon, Your Honor.
Good afternoon, Ms. Westmoreland.
On November 28, 2023, at exactly 5:56 p.m., per your instruction, I sent over to you, Your Honor, and to Mr. Kearns, and to all of the defense counsel, and to the state, proposed instructions in reference to Detective Belknap. The state responded November 28, 2023 at 11:35 p.m. with their proposed instructions. Accordingly, Mr. Steele sent back his objections to the state's proposed instructions. And November 29, 2023 at exactly 5:41 a.m., the state, specifically Ms. Hilton, I will read in relevant part, said, "Good morning. The state would like to make clear, for the purposes of the testimony beginning today, Detective Belknap is solely testifying in his expert capacity. Detective Belknap will be testifying later in the trial in his role as investigative officer." The state made this clear as they stated in their email. They made it clear to this court and to all of defense counsel that Detective Belknap, starting that day, would be testifying as an expert only in his expert capacity. I sent over the proposed instructions per your instruction, and the state made clear to this court and to us that after Detective Belknap testified in his expert capacity that day, that he would only be recalled as a fact witness only. Thank you, Your Honor.
Okay.
Your Honor, I can definitely re-forward the email to the court. And I could forward the whole chain of emails, including Ms. Hilton's response.
Well, I believe it was told to me that that's not inconsistent with what you all said, what was told to me. The challenge or problem that I, as your trial judge, is facing is whether or not that comports with the best practice of giving this limiting instruction. So that's kind of what I want to kind of think about. So
Your Honor, when first read, I have that email.
The issue is not really your conversation with another. It's what I just told you just a second ago. What you all agree to is not necessarily what I'm going to rule upon or what I'm going to agree to. So I got to figure that out, and that's what I haven't figured out yet. And I'm asking for you all's input as to that respect. You know, the United States versus Hogan, and there's some other case law. I'd like that to be the issue that I resolve. That's what I want to resolve.
I need to correct these instructions.
Okay, all right. We need to take our break. I'll come back and we'll talk a little bit more, and I'll make a decision as to how we're gonna handle the rest of it. Okay?
Your Honor, it is gonna take longer than we can. I mean, I was just saying, If it is going to take a little bit longer, Your Honor, then we can surely bring Investigator Belknap tomorrow.
I know.
We can stand down on what our position is if we just need some time to deal with
Let
this,
me
Your Honor.
just kind of Mr. Sharp?
Just if I could just bring one thing to the court's attention. State's Exhibit 1 is the PowerPoint presentation, which is very extensive about the gang testimony that Officer Belknap gave on the first day of testimony. So it is available for the court's review as well. I just wanted to remind the court that it's in evidence.
Yeah. I want you all to think about while we're taking our break, the United States versus Hogan, as well as the Golden Peanut case that we have here in Georgia. It seems like there's more federal case law in terms of how, or how a dual purpose witness is supposed to be dealt with. So that's what I'm going to think about over the next few minutes and see how that goes, okay? But anybody else before I go? Mr. Steele, anything?
I do have motions, but they go to the actual testimony. I can do that now, or we can wait till you decide.
Yeah, how long do you think it'll take, sir?
I'm targeting motion, 30 minutes.
Yeah, okay, I'm just trying to, just for planning, okay? All right, okay, all right. We'll be in recess, come back.
Thank you, sir.
All right.
Are they done?
Okay? All right. Council's given the hour. I think it would be prudent for me to excuse the jury for today. And then we can take up the potential issue as to the limiting instruction, as well as anything in regards to anything other substantive that Mr. Steele wished to raise. So, was there anything else we need to take up in regards to that issue? All right, Mr. Short, you rose. Anything else, sir? Mr. Short?
Yes,
Was there anything else other than those two things?
I believe so, Your Honor.
Okay.
I view them as three issues. Well, two if we exclude Mr. Steele's issues involving his client alone. We still have the issue, in my mind, of the repeatedly calling.
That's related to the first
Okay.
two.
Okay, yes, Your Honor.
Okay, all right. Okay, Sergeant Ingram, if you could summon our jurors for us, please. Thank you, sir. Before we do that, Mr. Adams and representative from the state, can you come up for a second? All right, ladies and gentlemen, please be seated. Okay. All right, ladies and gentlemen of the jury, let me tell you where we are at this point in time. We have a little more work that we need to do, and it doesn't require you sitting in your headquarters waiting on us, okay? And given the length and the hour of the day, it's 4 o'clock, we'll just take up that business and send you home, okay, for the evening. So, unless you just want to stay here till late in the evening. What do you say? Okay, apparently not. Okay, all right. Just want to make sure, you know. All right, okay. So, all right, ladies and gentlemen, if you could be here tomorrow for 9 o'clock for an anticipated 9:30 start time, our goal is to work till the end of the day, much like we did today, between sometime 4 and 5 o'clock, okay? So that's what we're going to do. Do tomorrow. Friday, ladies and gentlemen, we are still planning on you basically taking the day on that day. Okay, this coming Friday. All right. Okay. Now, related to Fridays, it was not the court's intention to cause one or a couple of you consternation for the 9th of February. That's next Friday. Okay. We are going to take an administrative day on that day to permit several of you to have to be seen and otherwise meet obligations that were pre-existing. Okay, so the 9th will not be an issue. So for planning purposes for you all, so this Friday and basically next Friday, you will have you will have the day. Okay, all right. What other ministerial inquiry of me do you have, ladies and gentlemen? Of me, if any? It's 2 days too early. I'm going to talk for a few more minutes. You'll have something. Okay. What's that? No objection? Okay. Okay. Well, I appreciate you. Look at y'all learning stuff all the time. All right. In the four walls of this courtroom. Okay. All right. Ladies and gentlemen, unless you have anything of us or of me, what I'll do is I'll release you and excuse you for the evening with your customary ad nauseum admonitions. Remember not to speak to anybody about this case. Do not discuss this case amongst yourselves. Do not have anybody discuss it within your presence and hearing, and certainly avoid any news media stories or any other print media about this particular case or any of its machinations, okay? And if anybody, of course, should try and talk with you about this case, then you need to let Sergeant Ingram and myself know immediately, all right? Remember to leave your notepads in the basket, pick up another juror sticker, and unless you have, like I said, unless you have any other inquiry of me, the last thing is, as I usually end off with, we really do thank you for your patience and your continued patience that you have given us and will continue to give us. So, ladies and gentlemen, that's kind of the schedule for tomorrow, and then tomorrow since you'll be out on Friday, we will be working because we have other business that we need to take up, and like I said, that's acceptable. Then on Monday. I should say tomorrow, which is Thursday, the 1st, I will tell you what pinpoint time you need to report for Monday. Okay? All right. So, ladies and gentlemen, again, thank you, and we'll see you tomorrow morning for 9 o'clock, all right? All right, all rise. All right, ladies and gentlemen, please be seated. Ladies and gentlemen, I have now our jury has left us. I'm going to seal this particular document, which I will mark as the next court exhibit in order. It pertains to one of our jurors that is going to have a procedure on the 9th. It will be, that's the reason that we had the conversation in regards to, well, originally we were going to work a little bit on the 9th. We're not anymore. In terms of the bench conference with Mr. Adams, if that pertains to he and he alone, if he wishes to explain that to you, he certainly may, but that's it. Okay? All right. Anything else in respect to any ministeria? All right. Okay, let's talk a little bit about did you all let Mr. Detective Belknap know that he's not required for today? Or can we please tell him tomorrow morning if he could be here for 9 o'clock?
Okay, yes.
And he doesn't have any problem with that time?
He should not, but I'll confirm that.
Why don't you go ahead and confirm that so I can tell him personally if we need to. Chris. This one needs to be sealed. Okay. All right. And we'll take his testimony. Is he the first witness tomorrow?
Yes.
Okay. Okay. And looking at U.S. versus United States versus Hogan, it's HOLGUIN at 51 F 4th 841 and continuing Ninth Circuit, which y'all's instruction, limiting instruction comes out of. Well as U.S. versus Rodriguez, 971 F 3rd 1005, Ninth Circuit 2020. And the Golden Peanut case cited by this court earlier from our Supreme Court of Georgia, written by Justice McMillan. This dual-purpose witness that we're talking about, Detective Belknap, Mark Belknap, testified the first day in an expert capacity. The challenge that the court has right now, and I'll invite discussion about, and I have not ruled upon as of yet, is, and I recall from the first time from looking at the transcript of the proceedings from that day, Detective Belknap testified, which was November the 29th of 2023. Two things: he was subject to being recalled, and secondly, he could be further cross-examined. The challenge that was raised by Mr. Shart and others is the state wanted to call him in differing 3 different times to, I suppose, discuss 3 different things as it pertains to the indictment in this particular case. So the issue from the defense's perspective is that this might cause confusion in terms of the jury, or place undue weight in terms of what his testimony was, or not being able to properly gauge it. So the 3 cases, Hogan, Rodriguez, and the Golden Peanut case, kind of give the court some direction in terms of what courts should do in terms of when faced with a dual-purpose witness. So as to not unduly emphasize particular witnesses' testimony in terms of opinion as well as expert, and to separate the 2. So I have been given a instruction. Who has it been authored by? Is it a combination of authoring by the state and the defense, or who it is authored by?
No, Your Honor, the state authored the proposed jury instruction and forwarded it to the court and opposing counsel.
Has there been any additions or modifications? I'll include it as the next court exhibit in order.
Not from what we submitted, Your Honor.
All right. Currently, as worded, it reads as follows. You're about to hear testimony from investigator Mark Belknap, who will testify about facts and his opinions and the reasons for those opinions. Fact testimony is based on what the witness personally saw, heard, or did. Opinion testimony is based on the specialized knowledge, skill, experience, training, or education of the witness. As to the testimony about facts, it is your job to decide which testimony to believe and which testimony not to believe. You may believe everything a witness says, part of it, or none of it. As to the testimony of the witness's opinions, this testimony is allowed because of the specialized knowledge, skill, experience, training, or education of this witness. Opinion testimony should be judged like any other testimony. You may accept all of it, part of it, or none of it. You should give it as much weight as you think it deserves. considering the witness's knowledge, skill, experience, training, or education, the reasons given for the opinion, and all the other evidence in this case. You should consider whether the witness testified to personal observations or involvement as a fact witness or testifying to an opinion based on specialized knowledge, skill, experience, training, or education. When a witness provides opinion testimony based on knowledge, skill, experience, training, or education, that person might rely on facts that are not based on his or her personal observations or involvement. But that opinion cannot serve as proof of the underlying facts. And this comes from the Ninth Circuit Model Criminal and Jury Instruction 3.5, and it references two cases, the United States versus Hogan and the United States versus Rodriguez. The other thing that the court has already undertaken that Rodriguez recommends that we have done already is that Detective Belknap has already gone through a Daubert pre-admission expert determination, which was done earlier, and the court is satisfied that as a preliminary gatekeeping function that he would meet the qualifications for an expert and authorize him to testify as one, be given the foundation to be laid. So my questions at this point in time are, and I asked to say this before, is why can't we just bring, or why can't Belknap, because this issue is going to come up with other witnesses, how come you just can't bundle all of them up at once and just take them all and maybe just make it simpler in terms of the ability for the court to go ahead and then give an instruction? That's my first question you need to answer for me. I know you told me you prefer to go ahead and do that, but why couldn't you just kind of just say, okay, all right, directing the witness to ask whatever, this date, blah, 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 yeah, such and such date, such and such a date, and then as the case law recommends, transition to, if I give the admonition to begin with, then you can tell the court when he's transitioning from being an expert to a fact witness.
Yes, Your Honor. So the reason why we're asking for Belknap to be called. The reason why we're asking for Investigator Belknap to testify now and then later is because his next set of testimony, which will be for 3 specific instances, which will be about an arrest of Mr. Huey in 2020, which that evidence hasn't come in yet. And then the next time he will come back after that is regarding the arrest of Mr. Nichols and Mr. Jackson in 2022. And then the last time will be his involvement as a fact witness when Mr. Williams was arrested at his home on May 9th of 2022. So the reason why we're asking for it to be separated is because those next 3 instances are primarily facts. That is just what his involvement was in those 3 arrests and those interactions. At this juncture, Your Honor, the reason why we're asking for Investigator Belknap to be called as both a fact and an expert witness in this occasion is because he has had previous interactions specifically with Trontavia Stevens, who has just testified. And so he would be, as a fact witness to Trontavia Stevens, impeaching some of the things that Mr. Stevens said on direct. And that is, we would not want to wait months or weeks down the road until we get to these 3 instances for him to be able to testify as to facts as to Mr. Trontavia Stevens. Additionally, Your Honor, at this point, the defense has cross-examined Mr. Stevens and other witnesses about particular pieces of evidence, such as whether or not, for example, Mr. Steele went into a line of questioning with Mr. Trontavia Stevens about whether or not Mr. Williams might be a studio gangster or some things of that nature. Additionally, Your Honor, there's been some cross-examination, or excuse me, Mr. Stevens has elicited on direct, maybe on cross as well, that Mr. Williams and some of these other defendants sitting in this room are not members of ROC Crew, or weren't really members of ROC Crew. And we now have what we believe Investigator Belknap will testify to tomorrow is specific tweets and things of that nature that he pulled himself regarding directly addressing those particular issues. And so we believe it's prudent at this point to have Investigator Belknap come back, one, as a fact witness as it relates to what he's done with Trontavia Stevens, as well as things that he's pulled, that he's observed as it relates to the testimony that has already come out. In transitioning to his expert testimony, Your Honor, the state would expect that some of these tweets that we intend to get into has language that we believe that in his expert opinion, he could enlighten the jury as to very specifically. And so that is why we're asking for him to be called tomorrow as both a fact and an expert witness. And
So
Your
are
Honor,
you going to, I'm sorry to hijack you, but I need to ask this question. Are you going to delineate what he's testifying in terms of fact and then expert?
yes, Your Honor.
So that we could, so that I can give a particularized limiting instruction?
Yes, Your Honor. So the state has created its questions such that there is a clear bifurcation. I call it phase 1 and phase 2.
So when am I going to give this particular instruction?
The state would believe that you would give it prior to his testimony. So before he testifies, letting the state know what this witness, what the intentions are. And what the state would ask is, when I complete phase 1, we could take a break, whether it's a comfort break at that time or a lunch break, depending on what time it is, and we can come back for phase 2, which would be the expert, because there is a clear bifurcation between what is fact and what is expert, to keep it very clear so that the jury knows there is a distinction. But the way that the state's questions are designed is to bifurcate the two testimony, and we could literally take a comfort break between phase 1 and phase 2.
All right. Okay. Mr. Sharp?
Your Honor, the state's proposal does not address the defense's very legitimate concerns. They're essentially seeking to call Investigator Belknap repeatedly to ask him questions.
3 times, I think 3 times.
Well, and just to be clear, on behalf of Mr. Stillwell, I don't necessarily have a problem with them calling him as a fact witness about different acts. The issue I specifically have is with them calling him as an expert repeatedly. If they are calling him as a fact witness tomorrow regarding some interactions he had with Mr. Williams, Mr. Steele may have something to say about that. I do not. But to have someone, this case is music in some ways. It's like a chorus. The state wants to keep calling this expert to sit in front of this jury, very close to this jury, and repeat their expert testimony as with all his training and all his accolades again and again and again and again. And there's a reason why chorus exists in a song. It's catchy, it sticks with you, and that's the repeated testimony that they want to bring in again and again and again in front of this jury to repeat the same things. Your Honor, there's an extensive PowerPoint that talked about Rock Crew, that talked about Bloods, that talked about sex, money, murder, that talked about colors and red and bees. And yes, Mr. Stevens testified to what he testified to, but Detective Belknap already testified as an expert about what a B stands for and what red stands for and Rock Crew and where Rock Crew's from. So there's no need to retread that information and go over it again and again and again.
Wouldn't it go to impeachment, potentially?
Impeachment, no, Your Honor, I don't believe that it's proper to impeach a lay witness with expert testimony, and to the extent that that it is impeachment, it's already been said. Just you don't get to re-impeach people. He said, Investigator Belknap said what he had to say as an expert. Trontavious Stevens said what he had to say as a lay person talking about his tattoos, and the jury gets to consider both testimonies and make their decision. But Investigator Belknap does not get to testify 5 different times as an expert, and Trontavious Stevens testify once. That's the problem with the chorus. Your Honor, it's cumulative. It invades the province of the jury. It violates our client's due process, or right to a fair trial. It also, quite frankly, Your Honor, it makes it very difficult to cross-examine an expert when there's no end to his testimony. We cross-examine someone.
You can cross-examine. I mean, look, there's some of you that wish to defer cross-examination to the end. I'll let you cross-examine him now and or at any time that he appears.
That's a bit of a Hobson's choice, though, Your Honor.
No, it's not. I mean, I'm not limiting your cross-examination.
Well, we're not saying
you can cross-examine him. You can cross-examine him any time about anything. I'm not even going to limit whatever it is you're trying to examine him as to.
If there's no end to the direct, Your Honor, it's very difficult to cross.
Well, the direct, you know what the direct is. Direct is the state's case. I mean, I mean, you do have some ability to know what you're going to, potentially examine him on.
Well, when you can repeatedly call the same witness to testify again and again and again about the same materials, there really is.
Okay, but here, and I hate to hijack you, but the state's given me a kind of a logical reason as to why they want to call him these 3 times. Not that they're calling him for shucks and giggles. They're calling him because of the way that they're trying to put on their case and the sequencing. So it makes sense in terms of that. It's not like, where they're just kind of putting forth a way to kind of get him, in front of the jury, as you call it, to sing the chorus over and over again. It's not that. They're trying to kind of make it as simple and as plain as possible for people to understand.
And to the extent that they call him as a fact witness.
So your heartburn is you don't want him to be called as an expert in the same breath.
Absolutely, he's already testified as an expert.
But the case law seems to indicate you can do that.
I respectfully, Your Honor, I have not seen that case law.
Hogan. I mean, I can tell you from Hogan right now. Okay, it has in here. Okay.
Yes.
Even as one of the large head notes. Dual role instructions. It's got it right in here.
Right.
Okay. And it talks about the district court twice instructed the jury on dual role testimony. First, before Officer then Rodriguez testified, and second at the close of the case with language hewing closely to our model instruction. But that's where that. So courts have struggled with this issue because you had a witness, much like a Detective Belknap, who is going to offer fact as well as expert testimony. The problem with, or the challenge in those particular cases is, one of them was, you need to have them, you need to still go through the Daubert expert gatekeeping, which we did in this case, which we did in Belknap's already gone through that. So that's not an issue. So the other concern that the case law in particular, Hogan seems to indicate is just to make sure that we have, the jury knows what is being offered and for what reason, and that it's not unduly emphasized. That's why the instruction was given. So to your discussion, and then the Golden Peanut case that Justice McMillan talks about is a police officer that was offered for a dual role, but again, a little different than our case. In the Golden Peanut matter, there was no predicate laid for our Daubert expert determination. So that's why it's a little different in our case, so that's why I'm asking you to really kind of just focus on that. I understand what you're talking about.
I can take some issues off the table. I completely agree with Your Honor about the Daubert issue, okay? And I also acknowledge that the cases we're talking about deal with dual roles. I get that. But those cases, as I understand them, don't involve repeatedly calling the witness as an expert again
I
and
agree.
again.
I would agree with that. And I'm
Okay,
going
that's
to
my
ask
only
the
point.
state to kind of deal with that, because that is something that is not dealt with in any of the, have you found any cases, Ms. Hilton? Yes. That have indicated that sequencing is fine?
Yes.
Okay, what is that? And can you give it for the good of the order?
Yes, I have two cases, Your Honor. The first case is going to be Mitchell v. State.
Mitchell v. State,
Which is 222,
222,
Georgia App, 878,
okay,
which is this is an older case, but it's good law, 1996.
1996,
Yes, and then we also have a federal case which really specifically talks about experts, which is going to be United States versus El Mazain, EL-MEZAIN, which is at 664 Federal 3rd, 467, which is a Fifth Circuit Court of Appeals case dated December 7, 2011.
okay, and what does Mitchell indicate to me?
Yes, sir.
Does it demonstrate anything about a witness being or an expert being called multiple times?
So this is just generally, but the trial court has discretion to allow such repeated testimony by, this case was an unsequestered lead investigator. So this, the Mitchell v. State case dealt with the lead investigator being called multiple times in that case, and that lead investigator actually sat at the table with the prosecution, and they were allowed to be called multiple times, being unsequestered, and the court said that that's in the discretion of the court to allow the lead investigator to sit. So not an expert, but that was a law enforcement officer being able to be called multiple times.
Okay, all right, what about an expert?
So El Mazain specifically talks about an expert, and in this case, Your Honor, the expert was a Hamas expert, or an expert on Hamas. And the expert came the first time as a general expert. So they really talked about generalities of Hamas and things of that nature. Then, as a result of cross-examination by the defense, that expert was able to be called back again to talk specifically about Hamas and specifically the evidence in that particular case. And Your Honor, that is exactly what the state intends to do here. Investigator Belknap was called as the first witness to talk about general terms, general gang evidence, very general. Now we are asking him to come back to testify to specific evidence that has been now introduced in this case. Prior to him being called as first witness, there was no evidence introduced. But now, because evidence has been introduced in this case, we want him to come back and speak with specificity regarding the evidence in this particular case. And we believe that this is analogous with United States versus El Mazain. And I will quote from the opinion. It says, as noted above, Levitt was the government's expert witness on Hamas, and he testified twice at trial. First, he gave an overview of the rise of Hamas and the role that Hamas social wing played in the accomplishments of its goal. That testimony has not been challenged. Second, the government recalled Levitt to provide testimony about evidence that had already been admitted through other witnesses. The evidence has shown telephone calls, financial transactions between defendants and Hamas leaders between 1989 and 1993. It had also shown the presence of the defendants' names in the telephone book of Hamas leader Marzouk. Levitt was recalled to testify about the relative inaccessibility of the Hamas leadership to the general public, which highlighted the significance of this evidence. For example, Levitt testified that the presence of the defendant's name in Marzouk's book was significant because this is personal and direct evidence of a relationship. He also testified that someone calling the public number for Hamas was not likely to get the senior leaders of an organization, etc. The defendants argue that Levitt's testimony about the significance of the context between them and Hamas prior to Hamas's designation as a terrorist organization was improper expert testimony under Rule 702, because the jury was capable of determining for itself what inferences to draw from the evidence. The government argues that Levitt's testimony was necessary in order to prevent the jury from assuming that Hamas leaders were available to anyone, or that those leaders engaged in a wide range of arm's length business deals with third parties. We find no reversible error. So in that case, they were allowed to testify twice. The expert, this is the same thing that is occurring here, as the state just alluded to. What we expect the evidence will be tomorrow is that investigator Belknap will talk with specificity about certain evidence that has come in, as well as introduce evidence specific to both sex, money, murder, YSL, and some of these defendants sitting here in this courtroom today.
All right. Mr. Sharp, anything else, sir? In that respect?
First of all, Your Honor, from taking everything the state, their analysis of that case is true, because candidly, I haven't had a chance to read the entire thing and digest it. We're talking about a Fifth Circuit case where the issue was a 702 challenge by the defendants, not specifically the recalling the witness numerous times. Now, the other thing, Your Honor, that's separating this case from the current case is there was absolutely, when we're talking, this is an investigation that apparently started around 2015. Discovery was supposed to end some time ago. And I've got to ask, why, if he needed to comment on this evidence that they're seeking to introduce through him, why wasn't that done on the date we started trial when he was the first witness? They could have easily introduced that evidence and asked for his expert opinion at that time. Additionally, Your Honor, a expert witness can testify to expert opinions, and the basis of those expert opinions don't necessarily have to be in evidence. So I'm having a tough time understanding the necessity from the state's perspective. I get the fact part of this, but as an expert, I don't understand why what the state is seeking to do tomorrow, why it wasn't done when Officer Belknap was on the stand in the beginning of this case, because that would have been appropriate. We would have dealt with all the expert testimony. They made the strategic decision to lead off with him, and that was a strategic decision they made. I assume they wanted to start strong and felt that he was a strong witness to bat lead off. But if you bat him lead off, you can't bat him clean up and bat him seventh in the order as well. You got to choose. And they chose. They offered testimony on direct, and he completed his testimony as an expert. And this is completely unnecessary to repeat this chorus. And I do believe it's a chorus, and I do believe it's quite prejudicial, and it will have an effect on the jury if he's allowed to just repeatedly testify as an expert.
Give me the spelling for that case again, madam.
Yes, sir.
It's United States versus,
El Mazane, E-L
okay.
hyphen M-E-Z-A.
Oh, M-E.
Yes,
M-E.
Z-A-I-N.
664 F 3rd 467.
Yes, it is the site 515, 10 site 515.
All right, Mr. Sharp, what do you want to tell me?
Well, in Your Honor, aside from just a general objection, also the state indicated that they want to have Investigator Belknap interpret these tweets for the jury. Now, please keep in mind that Investigator Belknap has already testified about all these, the rock crew and Bloods and all these things. I'm looking at these tweets that are purportedly sent out by Mr. Williams. I love my rock fam. I see N with a Crip flag today talking about he with the rock, boys stop, never that. The jury has already been given this expert testimony. They have already been put in a position with this background expert testimony and purported knowledge to analyze these tweets. This is nothing outside. As they sit here today, having been educated, purportedly educated by the expert, they sit here, they'll sit here tomorrow with the proper background foundation to analyze these tweets for what they are. They do not need Investigator Belknap to testify a second time and to analyze what is quite honestly pretty evident what the state is trying to get across based on what Investigator Belknap already testified to. So this is not, at this point, this is not outside the ken of the jurors that we have, because they've already heard the testimony about Investigator Belknap informing them how he feels they should analyze these words: rock crew, Bloods, B, replacing a B with a C. They don't need that explained to them again. They get it. And so it's completely unnecessary to qualify him as an expert again, or not qualify him, but present him as an expert again to interpret what he's already, when he's already given the witnesses, the jurors, the information to interpret it as they choose. And Ms. Westmoreland also has something to add.
All right, madam.
Your Honor, the reason why I read you the emails back from November.
I don't have any issue with the email.
Well, thank you, Your Honor. The reason why I read them to you is because the state made representation to the defense and to the court, which was really simple. Detective Belknap would be an expert once, and then for the remaining of trial, he would be called as a fact witness. And we knew that he would be called multiple times as a fact witness. That is
Why are we changing up to this point in time, Ms. Hilton?
Your Honor, so when I look back at that,
Because I got your emails, I'm going to admit them.
yes, and that's fine. When I look back at the emails, Your Honor, we were talking specifically about the jury instructions that should be given. And on the 29th, when we responded, that was the response, and I believe, and I found it as well. I want to make sure. Okay.
I'm looking at it right now.
In the email, I said, I hope everyone's having a restful evening. The state would like to make clear for the purpose of the testimony beginning today, Detective Belknap is solely testifying in his expert capacity. Detective Belknap will be testifying later in the trial in his role as an investigating officer. As we have continued to go through this trial, when Detective Belknap left on the 29th and he was not cross-examined, we explained then that we would call him back as an expert witness. And 2 weeks ago, when I talked about Investigator Belknap, we said we would be bringing him back as an expert witness. Why? Because we do not know what was going to come out on cross-examination. We do not know what's going to come out as they are eliciting information. And so at this point, contingent upon what has come out on cross-examination, multiple areas of cross-examination, what has come out in multiple questioning of each of these witnesses, the state believes it is important that Detective Belknap can talk about certain specific pieces of evidence which has come in at trial at this moment that he is best suited to testify about. Because I know the next argument is going to be we have other experts. He primarily, and what we put in our notice of expert testimony, is that he is familiar with Rock Crew. He is familiar with the iteration of Rock Crew and YSL from the 2012 era and leading into 2017, 2018, and that is the evidence that is relevant in front of us at this moment. The defense has known since November 29th, after when he finished his testimony, that we would be calling him back as an expert witness. They were made aware 2 weeks or last week when we brought it up again that he's going to be called as an expert witness. So if the notion is they are unable to prepare, that would be disingenuous because they have had the opportunity to prepare, because we've talked about calling him back, specifically when they did not cross Detective Belknap on the 29th. And I believe, and the transcript will correct me if I'm wrong, asked if he was going to come back as an expert, is what I believe the inquiry was when we released him for that day. And so that is why we're calling him back as an expert to address particular things that came out on cross-examination, particularly about SMM, Rock Crew, some things with Trontavia Stevens, and other cross-examination questions that have come out about responding officers, why they don't take out gang warrants. It's a number of different areas that have been explored on cross-examination, which we believe Investigator Belknap is the best suited to be able to respond to in his expert capacity. Furthermore, Your Honor, while Mr. Shar has made an impassioned argument, he has not based any of that in any case law. The case law is clear from both cases that the state has cited to the court, that the state could call back a witness. We are asking, very similar to the Fifth Circuit case, that he is testifying in generality, but now we are talking about specific pieces of evidence that have come in that he can address as an expert. And so, Your Honor, that is the reason why we are calling him back. We acknowledge and recognize what was written. We're not running away from what was written in that email. But
a couple things. I don't have the email. I don't have the longer string email. I didn't get that one.
I'll forward it to you, Your Honor.
I have the second one regards to Ms. Westmoreland sent just a second ago about, I think,
Do you have
the one that has
whole
Keith
chain?
Adams?
Yeah. I want to forward the whole
Because I
chain.
think the last maybe in that string might be Mr.
Can you bring me my computer? Ms. Hilton, did you forward the whole chain?
The last person I have is the email from Mr. Adams, so that should
Okay. Does that chain include Ms. Love's response to me?
Yes.
Okay.
You talking about the state executive defendant, full charge?
Yes. Okay. Your Honor, a few things. So I believe that the email was just forwarded to you. And the email is important because it's in writing and it helps us not just rely on our memory. And what you'll see is that in response to our proposed instructions, because, Your Honor, you were already dealing with this. Detective Belknap, how many times he was going to be called, this issue was already presented to you. And you'll see in that email that in response to our proposal, that Ms. Love sent a proposal for the state and said, Detective Belknap is not a fact witness in this case. And she was mistaken. And so what Ms. Hilton did was to fix Ms. Love. I'm sure it was just a mistake on Ms. Love's part. Ms. Hilton, what she did on behalf of the state was to email all of us, including you, Your Honor, to fix Ms. Love's error and say, no, Detective Belknap is coming as an expert once, and then he is a fact witness and will be coming for the duration of trial as a fact witness. That is why Ms. Hilton started off her email by stating, to be clear. That was a representation to the court. That was a representation to us. And now,
What date was that, madam?
it was November 28th or 29th.
I'm gonna pull my account.
Hold on, Your Honor. I'm going to forward it to you now.
No, I'm gonna look at.
Okay.
If I was on this email stream, I'll look at, who was it sent from?
It was sent from me, Your Honor. Your Honor, this was, excuse me.
Okay, I have Miss Love's email on the the 28th at 11:35 p.m. And I also have your email. Actually, Ms. Westmoreland, your email comes first. It's at
5:56.
5:56 p.m.
Yes, Your Honor.
And then Ms. Love's email comes after that.
Yes, Your Honor. And in Ms. Love's email,
I'm looking at it right now.
I believe that it is the second line. Detective Belknap is not a fact witness in this case.
All right, and was there correspondence beyond that?
Yes, Your Honor. And so after that, you know, Mr. Steele objects, but he objects to the instruction portion. And then Ms. Hill comes in at,
That date, can I?
yes, Your Honor, that is Wednesday, November 29th at 5:41 a.m.
Okay. I see Mr. Steele's email. I will forward that to Ms. Jones Beaver as well. Mr. Steele's objection is that the modification is based on, this honorable court unlawfully comment on the evidence and knowledge and experiences of the alleged expert. Okay.
Yes, Your Honor. And then the next email from Ms. Hilton is clarifying the state's position because
That was on the
29th.
hold on. The next email from Ms. Hilton on the 29th at 5:42 a.m.
Yes, Your Honor.
Okay, state would like to make clear for purpose of testimony viewing today, Detective Belknap is solely testifying in his expert capacity. Detective Belknap will be testifying later in the trial in his role as an investigating officer. All right, so regardless of what you all discussed on, I get to make that decision at the end of the day. So I think at the end, you all are being advocates, and I understand that, but it still doesn't take away. I got to make a decision, Ms. Westmoreland.
Oh,
okay?
absolutely, Your Honor. And,
All right.
and I'm asking and I'm arguing to the court that while you're considering the decision that you're going to make, to take into consideration that in this trial, Your Honor, we've been through a lot, from late disclosure of hundreds of witnesses to absurd late disclosure of discovery in this case. And, Your Honor, you stated to the state that you were going to draw the line on these type of things. And so I'm asking you to please consider that the state represented that he would only be called once as an expert.
No, that
and
doesn't-
now, excuse me, I'm speaking, Ms.
No, they
Hilton.
didn't.
Okay, Your Honor.
They didn't.
Okay.
That's you all having a discussion amongst yourselves. That is not the state committing to whatever it is. I'm the one that has to make the decision at the end of the day. And as you all know, I still can change my mind
Oh,
depending upon
absolutely.
the circumstances. So can we move on to something else?
Yes, Your Honor, I will,
Okay.
I will say this in closing.
All right.
Is that when you just asked the state, why did they change their mind, and they gave you the explanation on, there's been some witnesses that testified. So basically, it was lengthy, but the simple answer is, we need to call him back as an expert again. That is what a course is. The state is trying to make Detective Belknap a super expert. If you don't stop this here, now he's going to be needed as an expert again. 4 witnesses later, he's going to be needed as an expert again. 5 witnesses after that, he's going to be needed as an expert again. They can't keep biting at this apple because that gives a message to the jury. It's a chorus for the song. It comes every minute. The state is asking you, essentially, they're not going to use these words, but they're asking you to make him a super expert.
Okay, all right.
And Your Honor, because I just feel the need to respond because the state keeps harping on the idea that they have 2 cases that support their proposition that it's perfectly fine to recall experts again and again and again.
The issue is the recall of a witness is within the court's discretion as to whether or not I have broad discretion in order to do that. It has to be for a proper purpose. So
It does have to be for a proper purpose.
But our appellate courts, our appellate court in the Golden Peanut case, and our federal brethren who have dealt with the issue of dual purpose witnesses, but the purposes for those cases are much different than ours because they didn't predicate a Daubert determination. You had witnesses that were kind of like qualified under the old standard and not under the Daubert standard. So we've taken away that particular issue.
Right.
So, but still, got to kind of determine the other issues of that. But I feel pretty confident that I'm going to give the expert charge at some point in time. I'm going to give the layperson charge at some point in time. And the jury is the ultimate arbiter of credibility anyway. So I don't think that the jury's going to have a problem with it.
Well, again, my issue is not the jury charges. That's not my particular issue. My particular issue is recalling this
You
gentleman.
said that 10 times.
I understand that. Well,
okay, so what?
Well,
all right.
They cited 2 cases, a Georgia case that had nothing to do with expert witnesses, and this United States v. El Mazain case, which is a Fifth Circuit Court of Appeals case, but also they're citing it for a proposition that was not an issue in the appeal. So this holding has nothing to do. It's completely irrelevant to the issue that we're discussing
Mr.
here
Sharp,
today.
at the end of the day, it's going to boil down to whether or not they're calling a witness for a proper purpose, and the court determines whether or not that purpose is proper. I agree with you that there will become a point in time that it may be subject to some additional rulings, but right now, I mean, I don't see any other issue with it, with calling Belknap. Now,
As a fact witness or as an expert?
well, look, he's subject to being recalled, so he can testify as an expert. When I'm taking a look at the transcript of his testimony from the very first day, one of the last things that was said was that he is subject to being recalled. You all deferred your examination of him at that point in time. I went down each individual person that was here. I'll defer to include you, Everybody did.
And I think it's
So he could be recalled, and at the end of the day, I'm going to make that decision whether or not he's subject to being recalled. He's properly subject to being recalled at this point in time.
well, clearly, I shouldn't say clearly, but if I'm not making it clear, to the extent that we are arguing that he should not be allowed to be recalled as an expert, that is me saying that I have no interest in cross-examining him if he's done testifying as an expert.
Well, I think that you're going to, I mean, it's your choice as to whether or not you want to examine him or not. That's your choice. However, he's subject to being recalled. He's being recalled for a proper purpose at this point in time. You can examine him about anything you want that he testifies to tomorrow or when he testified on the 29th of November. Is it 29th of November?
Yes, Your Honor.
29th of November. So you can certainly test it. You can certainly examine him fully, thorough and sifting cross-examination as to anything that he's testified to.
Well, I just want to make it clear moving forward that if I understand Your Honor is going to make your ruling, but we are troubled by the state's insistence on calling him repeatedly, and at some point, Your Honor, we're going to ask you to continue to consider the chorus that he is providing to the jury, and it's cumulative, and at some point
It might be at some point. You're right, but at this point in time, for the reasons that they said that he's being called for, that's a proper purpose, and I would probably allow that.
So, am I correct in saying that he is not going to be permitted to testify to generalized expert testimony about gangs, if there's very specific reasons?
I don't know what he's being called to testify as. I mean,
Well, that's kind of our problem, because right now we're looking without any guidelines, and we're saying, oh, well, he's just going to be called to testify about the PowerPoint again.
No, I think that from what Ms. Hilton represented earlier today, if memory serves me correctly, he's going to testify to basically impeach or otherwise educate as to some of the things that Mr. Stevens may have said to the jury that the state wishes to clarify. Is that sum and substance what you want to get at, Ms. Hilton? I'm oversimplifying it, I'm sure, but.
Yeah, in addition to some other specific evidence that relates to what has come out in trial thus far.
Thus far.
Well,
Yes.
but
and we believe that any objection is not right now. You have to wait till the testimony comes out. He can object to cumulative if you believe it's cumulative or whatever
And I'll
the
be
case
listening,
may
of course,
be.
Mr. Shard, if he testifies to something that we've already replowed, I'll make an appropriate ruling. So.
very well,
All
Your
right?
Honor.
Okay. All right. Mr. Shield was up already, so. Go ahead, sir. Did you wish to be heard on this issue?
I would like to, Your Honor.
Okay.
So I have like a kind of a bigger problem with this that I'd like you to consider. Around the 17th day of November of last year, you entered the written order. I gave your Honorable Court a copy. If you need another one, I have. I gave everyone a copy just to be polite. I printed out a copy, but in the second paragraph of that order.
Which, do we have it, Wes? Can I see it, please?
Can I see States 1 again?
Okay. I'm in possession of order granting Defendant Williams' motion for complete witness list and expert report. So, second paragraph says, additionally, all expert reports, their analysis, findings, and the basis for same must be provided to counsel for each person in Standard, Harris versus the state. These orders do not comply with the or may entertain any lawful sanctions. Mr. Steele, I think we've argued this ad nauseum in regards to your repeated efforts, and rightly so. I don't have any issue with that, with your asking for Belknap's report. He has not tendered a report. It's not of the question of that. If he had done a report, you'd get it, and I certainly would enforce that. Or if he testifies that he has written something, you're going to get it. But right now, there's nothing that the state has tendered that would satisfy that.
So let me just explain.
And also, have you talked to him or hadn't had a chance to interview him?
I spoke with him, and he's very nice, but he told me that he was very general and that he wouldn't speak with me anymore. That was before trial started.
Okay.
So the reason I'm asking you that is this second time now. If the court would remember, when the state called the first witness, as they were calling Detective Belknap, they gave us too, a copy of PowerPoint, State's Exhibit Number 1.
Yes, I remember.
And I looked through it along with the court, and you had to stop everything.
I
We had to
did.
go
I remember.
page by page, and why is that in here? Why are they getting it now, et cetera. I've asked. I still don't know where some of those items come from that the gentleman testified to.
Have you had an opportunity to talk to him about the PowerPoint or anything? Also, is Detective Belknap bringing any more PowerPoints tomorrow?
No.
Not bringing any documents tomorrow?
We'll be introducing documents to him, but he's not bringing anything.
Have the documents you're going to show him tomorrow been tendered to or given to the defense already?
Yes.
So I just got this, whatever time you gave it to me.
Well, let's clarify what you just got, because you got tweets.
Let me,
So I want you to clarify what you just got.
Okay, is it something that has already been introduced into evidence already?
No, can you give a timeline so I can get some context? Last week, the state provided what has already been in discovery. We identified what tweets that we were going to introduce through Detective Belknap. We made packets of those exhibits and gave those to defense counsel. There was tweets from Mr. Williams. It was Facebook messages from Mr. Eppinger, or what's reported to be Mr. Eppinger's Facebook page. We let them know what videos we plan on introducing with Investigator Belknap, and we gave them any other pictures or things that we intend to give to Investigator Belknap, and we gave them a complete packet. Yesterday, this morning, we gave 3 additional pictures that was contained. One was a picture of Mr. Brian Williams, known as Birdman.
Is this the what's it going to be? Is this so I can talk about it for the record? Is this what? Can you label these two as the next state's exhibits? Are these yours, Mr.
Yeah.
Steele? I'll give them back to you so you can have them.
That's fine.
And the state can identify them so that, for purpose of the record, so we can talk about them.
The picture of Birdman will be 57.
All right, state's 57 is Birdman.
Sorry, Birdman is going to be 58.
58.
W as in
Whiskey.
Yes.
All right, and state's
And what's the other picture?
Mr. Williams, allegedly.
The other picture of Mr. Williams, which would be 57 Williams.
Whiskey.
57 whiskey.
All right, and that's of Mr. Williams. Okay.
Yes.
All right.
And then we also gave them this morning 52 WA and 52 WB, and I can show the court copies.
Can I see
of
those,
that,
please?
which are screenshots of the video that we gave to defense counsel last week.
Okay, and who is purportedly in 52 whiskey out?
Alpha.
No, actually, there's two. Both of them are labeled Bravo.
I'm sorry, one should be Alpha and one should be.
Okay, well, you go ahead and rename whichever one you want, and represent them, please. because you got 2 Whiskey Bravos. Okay, so I have now before me 52 Whiskey Alpha and 52 Whiskey Bravo. Alpha is begins me and ND homie. And then the next one is 52 Whiskey Bravo. Who is in this particular photo?
Yes, Your Honor. Both these videos are videos from Mr. Trontavious Stevens that was on a social media platform called Social Cam back in 2012. So these are, like I said, screenshots from those 2 videos, which was previously provided.
And when were they given to the defense?
The screenshot were videos.
Both 57, 58, 52 Whiskey Alpha and Bravo. When were they given to the defendants?
Screenshots were given this morning.
Were they provided in discovery at any point in time?
I have to check as to the video. If it wasn't, we definitely gave it to them last week. Because this was something that came as a result of Mr. Trontavious Stevens' testimony. So I'm not sure if it was previously given, but as a result of his testimony, we found that he was given this. When he said that, when he talked about him not really know what blood is, he just became a blood when he was in juvenile. I think we looked for this after that.
All right, so is Detective Belknap going to testify as to these 3 things, these 3 photos?
Or these 4 photos, yes.
4 photos?
The 2 screenshots, as well as 57 and 58, and the videos associated with the 2 screenshots.
All right. So I'm going to order that he talk to the defendants.
I'm sure he will.
No, he's got to talk to him, or he won't testify. Okay? I'm going to talk. Am I clear about that?
Right.
Okay, because I don't want him saying I'm not going to talk to them. Because look, because you all told me that as a result, Ms. Love told me a couple of days ago, as a result of Mr. Stevens' testimony, that there were going to be more pictures. So I was put on notice about that. So I think that in all fairness, the defendants need to be able to talk to him. So.
And let me be clear, Mr. Belknap has never refused to speak to Mr. Steele. So I don't know what the assertion is.
Well, Mr. Steele just told me he said I'm not comfortable talking with you anymore about that. So I mean, look.
As soon as Mr. Steele said that, we texted Investigator Belknap, and his response is, I haven't spoken with him except the first day I testified when he told the judge and claimed I told him I wanted to go home. That was the brief moment after what happened on his first day of testimony. So this notion that he's refusing to testify.
No. Give me a second.
Not refusing to testify.
Let me just make this clear.
Just to be subject to interview or discussion with the defendants, their counsel.
Let me make this clear.
All right, sir.
I had a meeting with Detective Belknap. I'm confident it's audio and video recorded because I went to the City of Atlanta Police Department. It was in November. I could tell you the exact date if you let me look in my phone. Investigator Viverito was there. I started to ask questions. Detective Belknap, he's very nice. He told me, that's pretty deep. I'm not prepared to talk about anything more with you. And we ended the conversation. I was with him maybe 15 minutes. Then I get thrown into no report, everything you're saying. So yes, I would like to, it would help me to understand because as you know, and I don't know what they're named now or labeled, I don't know where these come from. I can't get context.
57, just to clarify, 57 is Mr. Williams. 57 whiskey is Mr. Williams. 58 whiskey is Birdman.
Okay.
Okay. And then states 52 whiskey alpha and 52 Bravo are screenshots purportedly of Mr. Stevens or his involvement.
And I want to litigate. I don't want to have all these stoppages, but in States 1, page 11, if the court would look, it's already admitted. I don't know where this comes from. I have spent a month looking for this post. I can't find it. It has no avenue for me to find where this is. This was given to us the day that he testified. A lot of what the state is doing, and I'm not casting aspersions, but a lot of what the state is doing is just handing things over and saying, here it is. And that was my objection originally, if you remember, to Mr. Williams' Twitter. It's all just like one line of a Twitter. I can't get context. I have to go find each one of the tweets, and it would just be a lot easier if I had the backup, which I believe Your Honorable Court ordered, not just if there is a report, but that we get the basis for the expert's opinion. That's how I thought your order read.
No, it just says report. Okay, so
then I was wrong.
it says report. Reports, analysis, and findings. And you're right in the basis. So yes, I would agree with you. You probably need to probably have more of a in-depth conversation with Detective Belknap. Now, here's what I would like to do, counsels. Why don't we call Detective Belknap and have him come over tomorrow morning? For 9 o'clock. I will, and you can tell him that the court has directed he come over and that he sit with any party that wishes to talk with him about the opinions that he's going to give for tomorrow, or any of these other photos that he's tendered, that he's given the last couple of days, so that they can understand the basis of that. And that what I'll do is I will reach out to our jurors and have them to come in at for a start time of 10:30.
Thank you, sir.
So that will suffice to give you all enough time. And if you need more time after that, I'll adjust it accordingly. Okay?
Yes, sir.
All right.
And I appreciate that. And then I do have the.
Where is Sergeant Ingram? Can you ask Sergeant Ingram to step inside, please, for a second? All right. Let me know, Ms. Hilton or Ms. Love, when you've reached out to Detective Belknap. You can come into one Charlie. That's fine. So, counsel, is anybody okay? Everybody okay with 9 o'clock? For 9? Okay, all right, so you all come at 9. Just a second. Okay, so that will be start time. We'll adjust the start time for tomorrow. Okay, all right. Mr. Steele, is there anything else in terms of? Before I ask about one more thing before we, I need to take up.
Well, I did not know that items came from Chontavia Stevens' old account. I don't believe it's impeachment if it's because he said it. Do you mind?
Just tell me what number or tell me what you're referring to.
It's a.
Sorry, it's 52
Okay, 52 Whiskey Alpha. It starts with MEND, homie.
Yes.
That one? Okay. By Rock Slug?
Yes.
Okay.
So what I heard Ms. Hilton state, Your Honor, is this is taken from a some sort of domain that belongs to Chontavia Stevens. It's not been identified as that. The state didn't ask him any questions of that. I don't have access to that, and I'm telling you, I don't have this in discovery.
I think that Detective Belknap may have found this. Is that what I heard?
Yes, Your Honor.
Okay, so you can ask him about that tomorrow morning, sir.
Okay, and then I'd like to see the context. I'd like to see.
You can
all
ask
the-
him that, and we can take up any of that after that.
And then I don't know if it's impeachment because it's dated, unless this is the wrong date, June 16, 2012.
That's what I see on the bottom of it.
So he'd be 11. He said he went to YDC at 11. So I don't see the impeachment if he said that he learned about.
Why don't you talk with Belknap, and then we have a full, if we need to have another conversation after that.
And then the last thing, Your Honor, that I'd like you to consider is there's nothing wrong with promoting or saying on the blood or walking around with a tattoo. It's the criminality to further a gang. So this really is just not probative. The state has
This being what, 52 Whiskey Alpha or what?
Yes, sir.
What specifically,
52
sir?
Whiskey Alpha.
Okay.
Elisa, yes. To take something and say, well, they use the word blood, or they're wearing a red bandana, or the person has a tattoo on them, or they're using the word slat or wiping their nose. None of that is illegal, and it's being bounced around by Detective Belknap, State Exhibit Number 1, and in this courtroom by the state, as if that is a crime. They have to connect it.
Well, I think also it's going to be a question for the jury to wait and sift. So, I mean, that's your assertion. That's what the state has another assertion. But specifically as to Whiskey Alpha, 52 Whiskey Alpha and 52 Whiskey Bravo, you can ask Detective Belknap what the context of that is and then we can have a further conversation in regards to that if necessary.
And I'm not trying to be, I told the court already, I told the state at the same time, like with Mr. Williams' Twitter, I don't need a Twitter person to come in. And I heard Ms. Love say, well, I could put in anything I want. But I do then need access to Mr. Stevens' entire domain because I have no idea what is really on there. So I know you said speak with Detective Belknap, but I don't know if he can give me access. But
Well, once you talk to him, I'm sure one of the questions you're probably asking is where'd you get it from and how deep is it? So if that's a question, I may require that it be produced.
Okay.
Especially if he says, hey, I got that. Well, it probably does need to be produced, thinking about it, ladies.
I'm sorry, what needs to be produced?
The Twitter feed he got this from, because it's something that he referred to or looked at, or if he investigated prior to this, then that would be subject to being disclosed.
It's two different things. So
Well, where did he get this from? You told me he got it from, he did some Twitter investigation.
No, Your Honor. The Twitter is for Mr. Williams' tweets, and he got Facebook from Eppinger. This came from a video source that people call Social Cam.
Okay, but has it been been turned, have all three of those things you just told me been tendered to the defense?
The entire video of this has been tendered over, but
Video of what?
this is a screenshot of a video.
Of
This
52
is-
Whiskey and Alpha?
Yes.
Whiskey
that
52 Whiskey Alpha and Bravo.
Correct. And that video, which is pulled off of a website, which we can talk about authentication, that entire video has been provided to defense.
that's
This
not.
is just a screenshot of that.
Okay, how long is that video?
One is 1 minute, one might be 2 minutes.
Okay, so that's been tendered to the defendants? Okay, all right. Okay, so Mr. Steele, it looks like that they've tendered that already.
Okay, I will do what you said, but I don't still see the foundation because I don't know who wrote those words. It was never asked to Mr. Stevens.
Your Honor, we can talk about authentication tomorrow and what comes from the authentic.
Yeah, why don't you talk with Belknap first, and then you get a clearer picture of what, if anything, may be objectionable, okay?
Yes, sir.
All right. Okay. All right, let's talk a little bit about the jury instruction. The proposed jury instruction. Is the state, is this pattern jury instruction been altered from the Ninth Circuit in any way?
I believe only with the inclusion of Investigator Mark Belknap, but the author is behind me, so.
I don't, is it the pattern, Mr. Uhelski?
Yes.
Has it been altered?
I put Investigator Mark Belknap in there. I can give the court the original.
Can I see the original pattern instruction?
We can email it.
Yeah,
If you could email it to everybody, I mean, generally, folks, courts don't get in that, if we stay on the reservation and kind of just in terms of what is authorized, and a pattern instruction gives us the ability to kind of just stay within those limits. So unless there's something that needs to be edited from there. But for the most part, patterns have been blessed by review. So I believe Mr. Steele's comment to Ms. Love in the emails that I've referenced earlier is that it has me, the court, commenting on the expert. So that's why a pattern instruction or a pattern that it's a limiting instruction is better for me to give. So then I don't run afoul of anything else potentially.
Yes, sir. We'll email it, and we did get this from the Ninth Circuit pattern jury instructions.
Okay, but has it been altered in any way?
No, we believe it's the only thing that's been altered was the name.
Was the name?
The unredacted version.
Okay.
And I believe Mrs. House is sending that over now.
All right. Are you sending it to everybody to include Ms. Weaver?
Yes, Your Honor.
Okay, let me take a look at it. We should have gotten the last one. I'll mark the email that was just sent and its attachment from Ms. Uhelski, Wednesday the 31st at 2024 at 5:40. I'll include the email and the attachment in terms of pattern charge 3.15 dual role testimony. It has option 1, facts and expert opinions, and option 2, lay and expert opinions. Option 3, facts, lay opinions, and expert opinions. And it's got a comment section. When was that proposed jury charge given, or a limiting instruction given, Ms. Hilton, or
I emailed
or Mr. Uhelski, I apologize.
the facts and expert proposed instruction Monday, I believe, and then today, in an abundance of caution, I emailed an alternative proposed instruction, which was option 3. So Monday and today, 1 and 3 were provided to this court and all parties.
All right. Hey Wes, can you print that, the first, can you print the first, one I read for the purpose of the record? One I read, I think it was. Whoops. That's one you forwarded me. 308 this afternoon. That's it. Can you print that? Print the full charge as a, print two things, print the working copy, print that, print the proposed instruction, and print the full instruction. Okay, so I have both of those. All right. If you ask one more time. Yes, madam, we can take a comfort break. All right. Anybody else who's so inclined as well, okay? Go ahead, go ahead.
Hey there, I'm Jesse Weber, and thanks for watching the Young Thug trial here at Law&Crime, where we bring you live coverage of high-profile trials and individuals accused of committing some pretty terrible crimes. I'll tell you one thing, it's a stark reminder that the world isn't always the safest place. Well, that is why I want to shine a light on this week's trial coverage sponsor, Morgan & Morgan. When you're injured, figuring out what to do next can be pretty overwhelming. That's where Morgan & Morgan, America's largest injury law firm, comes in. A whopping 3 million people turn to them every year. And their process is a game changer. Picture this. You submit your claim, you sign contracts, you upload documents, you communicate with your whole legal team, all from your phone. It's that simple. And what's even more impressive, an attorney reviews your case in just 8 clicks. That speed is remarkable. You submit a claim, they start fighting for you. And if you're concerned about costs, well, you only pay them if you win. There's no upfront fee. So if you're ever injured in an accident or at work, you can check out Morgan & Morgan. You can submit a claim in 8 clicks or less by visiting forthepeople.com/youngthug.
course, the authority and citations, but I'll print the page just for our discussion, okay? I'm sorry? Yeah, okay, that's fine. Everybody back? Sergeant Ingram? Yes, sir. All right, councils, I've handed out what will be the next court exhibit in order. It would be my proposed limiting instruction that I would read to the jury. I'll invite your comments at this point in time. As to additions, deletions, or objections.
Your Honor, I spelled Mark wrong.
What?
Probably been noticed. I want to be the first to copy.
Spell, yeah.
That was the one thing the state had to point out.
Well, I'm not going to give it to him anyway, so we have time to correct it. Yeah, I see that. Okay, all right, I should be much longer anyways.
Okay.
Okay. My best? Okay. All right. Okay, has everybody had an opportunity to read the court's exhibit? All right. Mr. Shart?
Your Honor, I've read the exhibit. I've also read the comments to the exhibit, comments that were attached to what Mr. Uhelski sent, and the comments itself suggest to me pretty clearly that it's better practice, and they say district courts, because this comes from from the Ninth Circuit. United States v. Ankrum, ANCHRUM 590 F3rd 795, Ninth Circuit 2009.
I see that. It says the court may also consider bifurcating a witness testimony, separating witnesses of perception or factual testimony from the witness's expert opinions.
Right. And then later on, when they talk about when there's 3 different types of testimony, 2 paragraphs down, they talk about, and again, as with option 1, the judge also might consider trifurcating the witness's testimony by separating witnesses' fact testimony, expert opinions based on education experience, and lay opinions. And additionally, Your Honor, there's a case from the Seventh Circuit, United States v. Jett, and that's 908 Federal 3rd 252 2018 case, and that case indicates, and I'm reading off in division in the background, it says.
What's the citation for? Is it JETT?
Yes, Your Honor.
What is the citation?
It is 908 Federal 3rd 252, and it's a 2018 case out of the Seventh Circuit. And
252?
Yes. And it says that this case offers the opportunity for the courts to clarify this proposition. It says, when a district court learns that the government intends to put on dual role testimony from a case agent, it should first encourage the government to present the expert and lay testimony separately. It says, seamlessly switching back and forth between expert and fact testimony does little to stem the risks associated with dual role witnesses.
It's head note 22. I'm looking at it right now.
I know you're reading it, so I'll just.
And Jet, was he qualified as an expert? That's the first question. Second question is, the district judge didn't inform the jury, like we're doing in this case, about the differences in the types of testimony. So that was the second issue. I'm going to do that in this case. So.
Well, Your Honor, I go back to that same paragraph. It says, indeed, juries may parse.
Answer my question first. Answer my 2 questions first.
Yes.
did Jet involve, does the agent qualify as an expert first? And then, I can already tell you, the judge, in this particular situation, the judge did not give a limiting instruction. I don't know if he's qualified as an expert. Which is part of the challenge that we've overcome already by qualifying Detective Belknap as an expert. The other things that you've mentioned are certainly some things that the court agrees that you don't want to put too much emphasis, but I agree with all of you that a limiting instruction needs to be given so that the jury can bucketize or figure out how they choose to apply it.
Well, Your Honor, it's my understanding and my belief that he did testify as an expert. They say
you don't know, though.
Well, they say even if Agent Vale's testimony was proper under Rule 702,
Was he qualified as an expert? Because that's the whole thing. If he was not qualified as an expert, that's what a lot of these cases when you have dual purpose, they're not qualified as an expert. They're testifying as an expert, but then under the new standard, that's the whole purpose, is that they used to be able to give, hey, I'm an expert in this particular issue, and I'm a fact witness in this. And as Justice McMillan points out in the Golden Peanut decision, that's part of the challenge. So we've overcome that by qualifying Belknap through Daubert already. That's one issue.
Yes.
It doesn't resolve everything, okay? But can you tell me with any specificity, since you cited Jet,
Yes.
whether or not we have an expert, an agent that's been qualified as an expert?
Well, Your Honor, the analysis seems to be assuming that he was testifying as an expert because then they're talking about the difficulties in parsing, for jurors to parse when the witness is testifying as a layperson and as an expert and going back and forth. So that seems to be the assumption of the analysis, that he was testifying as an expert. And they're saying even knowing that, even if the person is properly qualified as an expert, it's still very difficult for the jury to put the testimony in those different containers when it's presented to the jury all at once. And that's why it's saying, at least this case and the comment that was provided by the state suggests that the testimony should be bifurcated or trifurcated and cleanly separated. And I would suggest, Your Honor, that's to not run afoul of the comment and also the authority in this case. The state needs to clearly delineate between the types of testimony and not present them as interconnected and interspersed, but do one, then the other. And that seems to be exactly what this analysis is referring to.
All right, anything else, sir?
Because, I mean, clearly, Your Honor, in this case, the Jet case, if the individual is not testifying to firsthand knowledge, he would be testifying as an expert, because otherwise it would be hearsay.
Well, he's testifying to facts and opinions.
Right, but I mean, if he's testifying to opinions, he's testifying as an expert, as I understand it.
Yes.
So I guess the answer would be yes, he was. Did he go through the Daubert qualifications? I would think so, but to me, that doesn't necessarily change the analysis.
Anything else, sir? Thank you.
No, that's it.
State wish to respond?
Your Honor, I'm going to just point out from, if I may.
Yes, Mr. Helsey.
Ms. Hilton on the details of this, but in looking at Jet, it says, Pin Site 270 says, the procedures for properly admitting dual role testimony were not followed in this case. And then the instruction that they do refer to is from another case, I guess Garrett. That's all at Pin Site 270. And all the concerns that Mr. Shard has voiced are consistent with the pattern instructions that the state has proposed, and I'll let Ms. Hilton follow up on that.
All
Hey,
right.
Your Honor, I was just going to say, also looking in the comment section, the comment section also cites to United States versus Ankrum, ANCHRUM.
That was one Mr. Sharp just cited.
Oh, I thought he started Jet, but
He started Ankrum before
Ankrum.
then. Yes.
And in Ankrum, the holding that the district court avoided blurring the distinction between the case agent's distinct role as a late witness and his role as an expert witness when it clearly separated the agent's testimony to a first phase consisting of his percipient observations and a second phase consisting of his credentials in the field of drug trafficking and expert testimony regarding the modus operandi of drug traffickers. Your Honor, I believe earlier that's what the state alluded to, Your Honor, is that it is the state's intention to have a phase 1 and a phase 2, and I believe I use those terms precisely, that phase 1 will be solely fact testimony, and then phase 2 will be expert testimony. And I said, even to make that distinction even clearer, the court could take a break between phase 1 and phase 2, because I believe it will be a clear demarcation between phase 1 and phase 2.
All right.
And the state could let the court know when we conclude phase 1 and we're transitioning to phase 2, which the state intends to do and intended to do, based on reading these cases prior to this hearing this afternoon.
Okay, Your Honor, if that's the state's intention, I don't think that intention clearly made it to that side of the courtroom, and I'm not blaming the state, but that's our concern. So if the state plans to clearly delineate between the two and bifurcate or trifurcate, I think that would be following the rules of those cases that
All
I
right.
just presented.
Okay, thank you, sir. Anyone else wish to be heard on the issue of the limiting instruction before Detective Belknap? Okay. All right. That'll be the limiting instruction I give tomorrow before he testifies, okay? When we have our jurors. All right, with that, ladies and gentlemen, any other ministerial inquiry of me? Okay, so just for tomorrow morning, you all report for 09, courtroom 1C. Have a chat with Detective Belknap. I will be available. I will be in chambers, and I've instructed our jurors that they will report for 10:30. I'll come out probably about if you all have concluded your business. If you just let one of the sheriff's team know. Then I can come down and talk with you, assuming all parties are in place at that time, okay?
Yes, Your Honor.
All right. Any further inquiry of me?
Not on behalf of Mr. Williams, I'm just assuming, that Mr. Williams' Twitter can come in without a foundation by both sides, because I think we discussed that yesterday. And if that's not true, then I don't want to cause a ruckus tomorrow, but that was my original motion. Ms. Love said that all Twitters can be played or whatever, reliable.
So, Your Honor, we are prepared to address certain tweets, and we can do that in the morning, but we do have a response to Mr. Steele regarding tweets, what tweets we believe could come in under like a rule of completeness argument, and so we can reserve that in the morning, but we'd be prepared to argue that.
Why?
Why? I mean, we could do it tonight.
Because I got jurors in a box.
I mean, we could do it tonight, Your Honor.
I got jurors in a box.
Yes,
How many times I got to tell you all? I don't like stopping. I really like those people to hear what you all have.
You're right. I would just think it was 6:30 in the evening, but we can have the
Look, do you have the tweets?
We have.
Okay, Mr. Steele's asking, is he going to have to basically, will they come in without foundation, without requirement of a custodian? Is that what you're saying? Okay, that's what he's asking.
So I think there's two different issues. So foundation and authenticity, that's one issue, but whether or not can come in, we believe some of the tweets that Mr. Steele will be trying to get in is self-quotation.
Okay, that's different. That's different. So
foundation.
what he's asking is, does he have to worry about having a custodian? Are you going to admit, basically saying without him going through the nut roll of getting somebody here from Twitter?
No, if he could pass the self-quotate, the other admissibility.
No.
we're not gonna have-
The record as a whole is admissible, just like any business record. Okay? No. Just stop shaking your head, Miss Love. I run this show. Okay? Stop shaking your head. All right? All right? You all don't understand. When you do an authentication document, the document itself comes in. It's subject to other objections, but the record itself, what you've done is you've taken out the foundation requirement. That's all it is. It's still subject to other objections, lawful objections and invalid objections, such as hearsay or other things that would be appropriate. So that's all it does.
Yes.
So he's asking, for the third time now, if you're going to object or require a foundational custodian or others to come in and basically testify about that or authenticate that this is Mr. Williams' Twitter record.
No, we will not have an authenticity objection.
Okay, so the thing we got to argue over tomorrow is whether or not his statements come in or fall within some particular exception.
Yes, Your Honor. Exactly.
Does that answer your question, Mr. Steele?
Yes. Thank you.
All right. I don't know why that was so difficult. All right, anybody else? Okay, all right. Okay, unless y'all have anything else, I will see you all in the morning, okay? All right, we'll be in recess until tomorrow morning, and I'll see you all then. All right. Miss Weaver.